All right, sir, your name?
No.
All right, Mr. Anderson, you're here in 2023 MM 2173AO. It's one count of trespass other than a structure or conveyance. Was there an offer to resolve this one?
Yes. Oh, sorry. Are we not accepting? State did convey an offer to Mr. Anderson of a withhold, credit for time served, and no return to the old Cheney Plaza.
All right, what are we doing with that one?
Your Honor, it does appear that he may not have any history. I don't know if we've had an opportunity to discuss the offer with him, but if he needs more time to discuss it in more detail, we would be asking that he be released to ROR.
All right, he's out on bond on 2023 CF 1535AO. I'm assuming that hasn't been filed on, right?
I will double check 1 second. No, Your Honor, not yet.
All right, any objection to ROR?
No, Judge.
All right. All right. So I'll appoint the Office of the Public Defender to represent you. We are going to release you on your own recognizance, so be released as it relates to this charge today. The conditions are going to be that you maintain contact with your attorney. That way you don't miss court. The best way not to miss court and not have a warrant issued for your arrest is just stay in contact with your attorney. So I'm going to put that in the court order that you stay in contact with them, all right? Also that you do not return to Cheney Plaza, all right? All right, good luck, sir.
And you're taking no action on the out on bond, Your Honor?
Correct. Thank you.
We actually do have our sign interpreter.
Oh, she's here?
He's here.
All right. Well, we'll do Mr. Thompson whenever he's ready. If there's other people there, is this him? All right. Madam Interpreter, have you been sworn? All right. Do you swear affirm to translate from, it's American Sign Language, right? American Sign Language to English to American Sign Language to the best of your ability here today? All right, thank you so much. All right, sir, your name? All right, Mr. Thompson, you're here on one count of possession of cocaine. I reviewed the arrest affidavit. I've determined that there is probable cause. I'm going to appoint the Office of the Public Defender to represent you. We're going to stay the bond at $1,000. Okay? All right, good luck to you, sir. All right. Madam Interpreter, do you need the case number?
Public Defender's Office phone number. So he can stay in touch with his attorney. So he can contact and stay in touch with his attorney.
All right, good luck.
Thank you.
All right, case number is 2023 CF 4068AO. All right. Sir, your name? What happened to Aspie? All right. Let's do that one first. 2023 CF 4046AO. Appoint the Office of the Public Defender to represent Mr. Aspie. Reviewed the arrest affidavit. Do determine there is probable cause. Stay the bond on that case at $5,000 with no contact, no return, no weapons, firearms, or ammunition. All right, sir, your name?
Blake Coleman.
All right, Mr. Coleman, this is 2023 CF 4066A. It's one count of criminal mischief greater than $1,000. I've reviewed the arrest affidavit. Do determine there's probable
Your Honor,
cause. Yeah.
I actually don't believe the value is established, possibly assumed but not established in this one, so we would be objecting to the value. saying for lack of probable cause.
All right, state, yeah, I don't see anything other than the charge. Hold on. We're sorry to hear about your mother, by the way.
Thank you.
Your Honor, state we just asked for an M2 criminal mischief.
Yeah, there's probable cause for a criminal mischief, but only as it relates, a second-degree misdemeanor. So we'll set bond on that case at $100. You're being held on bond on other cases, but, you'll have bond on this case of $100. And I'll appoint the Office of the Public Defender to represent you, okay? All right, good luck.
And
The statute.
Madam Clerk, that will be 806.13, sub 1B, as in boy, 1.
Take a look at that.
Yes, 1.
1B1.
806.13, 1B1.
What was your name?
Thank you.
It's criminal, it's, yes, criminal mischief.
And M2.
What, less than 200 or?
So, yeah, you may have to let your attorney know that.
All right, sir, your name? Your name, sir?
Jeremiah, name is Elliot.
All right, Mr. Elliott, you're here on 2020 CF 8621AO. It's a warrant for a failure to appear in that case. Also 2019 CF 13842AO for failure to appear in that case. Each warrant stayed at none. I'll appoint the, or set at none. I'm gonna stay the bonds at none. Appoint the Office of Public Defender's Office to represent you in each of those cases, okay? All right, good luck, sir.
To do is contact that attorney, let them know you were in custody. They can, and they'll get you a bond motion to get you your bond back, okay? Contact your attorney on the case. So you'll have to talk to your,
We need to tell him about the Ohio warrant too.
and just let them know what happened and where you were at, and they'll help you, okay? Good luck with everything.
You mean Osceola out of county?
That was Mr. Elliott, right?
Yeah.
Was that open Ohio warrant?
Oh, it's not extraditable,
Okay,
so
all right.
it's not
All right.
Okay.
gonna be extradited.
All right, ma'am, your name?
Hi, my name is Ala Collar.
All right. 2022
And Your
MM2.
Honor, there is a PC argument, just for the court's information.
Yeah, I'm on the fence about it, so I'll hear argument. 2022 MM2190AO. One count of trespassing on property after warning, one count of misuse of 911. Let's hear the PC argument.
Your Honor, defense would be arguing that there's no probable cause to the misuse of 911. The misuse of 911 requires an element of knowledge. It seems like whether, reasonable or not, at the time, she was not in the state of mind to realize exactly what was happening. It seems like she was under the impression that she did need the help and use of 911. And for those reasons, we would argue that there's no probable cause.
And Your Honor, state we just alleged that the knowledge was the uniformed police officer stating he is Orlando Police in a department-issued uniform with the words police, the patch with OPD. There should be some inferred knowledge given that he was not undercover and in his full uniform.
Just the way it's phrased that she proceeded to call 911, that was my reading, that, I don't know, did she actually call 911?
Yes, I did.
Don't talk about anything,
never mind.
please.
But I thought I.
That's okay.
Your Honor,
that
there's
person-
also
that was
competency
a rightful-
concerns.
Obviously.
Thank you.
I was under the.
No,
impression
don't,
it
please
was a
don't say
rightful
anything. It's
reason.
okay.
We're not,
can
I know,
No, you-
but I'm talking
I'm
for
a
you.
I have a bachelor's degree. I'm
I
an
understand,
educated
listen,
woman.
ma'am, today's just your first appearance. We're going by what's written on the paper. What you say here today is not gonna change what's written on the paper. Instead,
No,
what
I'm
you-
not
listen.
trying to change it. I just
Listen.
want to tell my story.
Well, listen, today's not the day to do that. Anything you say, Keenan, will be used against you. Today's not the day to talk about what actually happened. We're just going by what's on the paper. So anything you say, Keenan, will be used against you. You have the right to remain silent at your first appearance. It's usually a very good idea to exercise that right. You'll have the opportunity to tell this somewhere down the road.
I was very offended by the lawyer who said I wasn't in the right state of mind,
Okay,
because I am.
all right, well, that's her job. So,
She didn't even speak with me 1 second. Not 1 second did she speak with me before the court.
all right, ma'am, I'm gonna ask that you just hold on 1 second, okay? I'm gonna find probable causes to count 1 and count 2. I'm gonna stay the bonds at count 1 at 500, set bond on count.
I'm homeless. I'm homeless. I do not have a car. I do not have a home. I cannot pay any bond.
Well, you have an
I
attorney?
am
Listen,
homeless. I am
Okay.
homeless.
all right, if that was criteria for getting out of jail, then that's all anyone had to say. It's not gonna happen here
It's
today.
not what I have to say, it's a
What's-
fact.
What's gonna happen is you may
It
be.
was at a shelter,
All right,
that's where
your
I
bonds are
was
set.
warned.
The PD's appointed. Good luck to you, ma'am.
And Your Honor, the bonds quickly, I apologize. I missed them.
Huh?
What were the bonds again?
500 and 100.
Thank you.
And then, was there no return?
I don't think you ordered one, but state would ask for one.
Okay, where was it?
It was the Lake Dot Circle, the William Booth apartment.
Okay, yeah, well, no return. Yeah. All right. Sir, your name?
Francis Collins.
Before him, Your Honor, we got,
Bowsorts.
he refused, Your Honor.
All right. She was here in 2023 MM2165AO. I'll appoint the Office of the Public Defender to represent her in that case. It's 1 count of loitering or prowling, 1 count of possession of drug paraphernalia.
And I apologize, Your Honor, is this on Balzortez?
Yes.
Your Honor, defense does have a probable cause argument for the loitering and prowling.
All right. Let's hear it.
Your Honor, the loitering and prowling occurred or allegedly the loitering and prowling occurred at a normal time of 10 a.m. There was no threat to public safety, and there was no evidence that a crime was occurring. And I do have case law if needed to
What
go.
about the trespassing? She was behind the no trespassing sign. Would that not be the crime? Because it said when they saw her, she was behind the fence that was posted no trespassing.
And the additional crime committed would be drug use, I believe smoking from an unknown object, and they found paraphernalia.
I understand the argument. I'm gonna go ahead and find probable cause as it relates to the loitering and prowling, which, usually they don't do that well, but in this case, there was conduct inconsistent with lawful behavior based on her being behind the fence that was posted no trespassing. So find probable cause as it relates to the loitering or prowling, we'll stay the bond at 100 on count 1, stay the bond. Find probable causes to count 2, stay the bond at 500.
And then in regards to her out on bonds, the 14601 is not filed, so state would ask for no action.
All right,
On the 2287 has also not yet been filed, so state would ask no action. And on the 14385, or 58,
14358.
also has not been filed, so state would request
All
no
right,
action.
we'll take no action on the cases she was out on bond on, but we'll appoint the PD and if we haven't already. All right,
Thomas Barnes is mental health.
all right. Was there an offer to resolve her case? Or his?
There was.
Or his case? 2023 MM2178AO. I'll appoint the Office of the Public Defender to represent Mr. Barnes. Do you
Your
want to
Honor.
reset it, or do you?
Yes, Your Honor, there is a credit time served offer, so we would like to reset it if possible.
Okay, we'll reset it for tomorrow.
Robert Bennett is mental health, Your Honor.
All right,
It's another one with a,
all right.
yeah.
23 MM2187AO. I'll appoint the office, well, we'll just reset it for tomorrow. All right, sir, your name?
My name is Safrente Jamar Collins.
All right, Mr. Collins, 23 MM2176AO, it's 1 count criminal mischief. Viewed the arrest affidavit, did determine there's probable cause.
That's fine.
There is no offer at this time, Your Honor.
Right. All right. I'm gonna stay the bond at $500, order that you do not return to 808 West Central Boulevard when you have no contact with the alleged victim in this case, all right? And I'll appoint the Office of the Public Defender to represent you, okay? Also that you possess no weapons, firearms, or ammunition, all right? Good luck, sir.
John Doe, behavior.
And your Honor, state didn't have an offer due to not being able to ID him?
Did not?
No.
Okay, all right, so we'll, 2023 MM 2164 AO, I'll appoint the Office of the Public Defender to represent Mr. Doe. Reviewed the arrest affidavit, do determine there was probable cause. We'll stay the bond on count 1 at 500, count 2 we'll set at 100. And then, well, I'm not gonna order him do not return to Aspire, because I think he was getting treatment there. Edwards is next, yes. All right. Alberto? Yeah, Garcia, Tenet.
Wait, Edwards didn't bond. Oh, I thought you said bonded.
Edwards bond.
Yeah, Edwards didn't, Tasia Edwards? She has a first appearance detainer. She didn't bond.
Yeah.
She does have a credit time served offer if she did not bond.
All right, well, sounds like we're gonna have to reset her for tomorrow anyway. So we'll reset her for tomorrow if she's still
No,
here.
no, no, she didn't, she has a hold for a FAD, so she did not bond.
All right, well, we'll reset her for tomorrow. Edwards,
She's in I holding.
We can get her and bring her up, Your Honor.
okay, hold on, just set her to the side, please. All right, so we'll come back to Edwards. All right. Garcia, Tenet? He's in the hospital? All right. All right. 2023 MM 2184 AO, it's 1 count of trespass, 1 count of disorderly intoxication.
And
Yeah, go ahead.
there's an offer for credit time served to resolve, and I did have a PC argument at the same time.
Well, you think, I mean, he's in the hospital, I'm not sure he'll be back here tomorrow.
Understood. What we could do is we could set it for 24 hours from return of the hospital, that it be set.
Can we do that?
Mhm.
All right, we'll do that. We'll reset it for within 24 hours from his return to the hospital. Return from the hospital. Hopefully he's not returning. Oh, Miss Lee. 23 MM 2182 AO. 1 pass, does she have a time served offer as well?
There's no offer on Miss Lee.
All right. I'll appoint the Office of the Public Defender to represent her in this case. Just by being in the vehicle, that's the trespass and the conveyance, even if she was the passenger.
Yes, Your Honor.
And then
I
the,
don't believe there's an element of knowledge that needs to be proven. I could be wrong.
although when I look at the statute, it says who's ever, the way it's written, it says you can be invited.
This used to come up in.
But it's not his car. We go back to like apparent authority and all that stuff. I mean, all right, there's enough for PC, I think, on the trespass and a conveyance. I don't know if there's enough for the resisting, because it sounds like it's, here's what the court, and the state can chime in if they want, but that he told her he noticed police. There's no allegation she saw police until she saw police and then she stopped. So they're saying that when he was in the car, he started driving fast because he told her he saw police. And then he parked, that the police lost him. He parked, he told her to run. She ran, and then as soon as she saw police and they said stop, she stopped. So I'm inclined to ROR on the resisting. I will find PC on the trespass and the conveyance.
Your Honor, state's only argument would there be kind of a implied knowledge in that law enforcement was behind them, then he started driving fast, recklessly, arguably to lose law enforcement.
Yeah,
And then I would assume abruptly stopped the car and ran, but still leave it within your discretion, Your Honor.
I understand. I'm gonna RR because he was the one driving. When they ran, he told her to run. And at that point, they had lost the cops, so there were no police around when he told her to run. And then she ran. And then as soon as the cops told her to stop, she stopped. So at the first opportunity, it seemed like. But so ROR on count 2, find probable cause on count 1, stay the bond at $250, order no contact with any co-defendants. She was also out on bond. We'll take no action on that case. Lee had 2?
It's 2 out on
Oh,
bond.
2 on bond. Yeah, sorry. Well, I'll take no action on either one of those. Uh-huh. All right, ma'am, your name?
It's Amy Milliken.
All right, Ms. Milliken, you're here on one count of resisting an officer without violence. Viewed the arrest affidavit. I do determine there's probable cause. This is 2023 MM 2183. I'll appoint the Office of the Public Defender to represent you. What's that bond and then count 1 at $250? I'm a question for, I want you to tell your attorney, but I want you to tell me. The 3312 Monica Circle, is that where she lives? Is that her address?
Yes, Your Honor.
So this crime scene, was that at her house?
It was at her parents' house, Your Honor, but she is currently residing there.
All right, I'm not gonna order you not to return there. But I will, as a condition of release, require you to not interfere with any investigation related to what happened there, okay? All right. Good luck, ma'am. All right, ma'am, your name?
Tasia Edwards.
All right, Ms. Edwards, this is 2023 MM 21860. There was a time served offer, is that correct?
Yes, Your Honor, state did convey an offer to Ms. Edwards of an adjudication and credit for 1 day.
All right, Ms. Edwards, so, the state's made an offer of credit time served. It'd be entering a plea to the offense of resisting an officer without violence. We'd sentence you to 1 day in the Orange County Jail with credit for 1 day time served. This is a criminal offense. You have constitutional rights as it relates to this offense, including the right to an attorney, the right to go to trial, the right to have the state prove the charges against you, the right to call your own witnesses, the right to confront the state's witnesses. All those rights associated with going to trial, have the right to an attorney assist you through the trial. If you want to resolve your case here today, you'll be waiving those rights, and you'd be sentenced according to the agreement, which was credit time served, or you can not accept the state's offer, and I'd be inclined to set the bond at, at $100, and you'd just have a bond, but you may get court dates in the future. So what would you like to do?
I just want to confirm that
Yep.
I'm sure I do another day in jail.
No,
Or I already have the time served.
we'd sentence you to 1 day with credit for the 1 day that you've already served.
Okay.
So you'd be released as it relates to this charge today. There's also court costs of $273. I give you, all right. All right, so the attorney next to you, she's got a plea form.
Okay.
The plea form, on the top of the plea form lists the rights we talked about, all the rights associated with going to trial. And by signing the bottom of that plea form, it says you understand those rights and you understand you're waiving those rights by entering a plea here today.
Okay.
The bottom part of that plea form talks some of the consequences of entering a plea, including if you're not a U.S. citizen, you'll be subject to deportation. If you've ever been convicted of a sexually motivated or sexually violent offense, you could be subject to involuntary civil commitment. And if you're on probation for a separate offense, a plea to this offense might be used to violate that probation. You understand all that?
Correct.
All right, you can sign the bottom of that and we'll,
No, I'm not on probation. at the
I would
moment.
advise you not to take it if you just.
And can I ask you something, Judge?
sure.
They said that I missed a court appearance.
I don't have that.
It's, she has a first appearance detainer, Your Honor. She's on pretrial diversion. She has an open case.
Okay. All right.
Is
Here's-
that?
Here's the thing too.
Yeah.
You're in pretrial diversion for a separate case, right?
Yeah, but they haven't spoken with me about that since our last court day. I haven't been officiated to go do probation or anything.
Right. Well, here's the here, it's not a problem. It's just, I want you to be aware that there's a chance you might be kicked out of the diversion program because of this new law offense, okay?
Okay.
If you enter a plea to it, that might have consequences as it relates to diversion. You're still free to do whatever you want to do. I just want you to be aware of that consequence. You understand that?
Sweet.
And are you taking no action on that PTD case, Your Honor?
Yeah, no action.
It's 2020 CF 014610 AO.
Here's what we're gonna do. I'm not gonna, because it's a felony that you're going to diversion on, I'm not gonna take a plea here today. State any objection to ROR. I just don't want her to plead to something and then her get kicked out of diversion and then have a felony be, on her record.
Your Honor, state is concerned regarding an ROR, because I believe that out on bond is a battery, a bat Leo, and this one is a resisting without, so also a,
Oh, it was a bat Leo?
yeah,
That Leo and a resisting with violence.
just given the
All right.
similar nature, state would object to an ROR.
I still don't want to take a plea today.
And Your Honor, defense understands the state's position. However, due to the lack of convictions and limited criminal history, and we would be asking for ROR still.
All right, I understand state's concerns. The fact that she's in diversion for a felony, the fact that this was resisting without, it was really just, and if I'm misremembering, correct me, like, they told her to get out of the car and she didn't get out of the car? Or what, was it? I mean, that was pretty much the extent of it, right?
Yes, Your Honor.
All right, so the court's gonna ROR you on this. I'm just gonna admonish you that you're in pretrial diversion on a felony. You're not a convicted felon. Becoming a convicted felon,
She does have a felony conviction, Your Honor,
she does?
for
Oh,
battery on Leo.
That's not on her face sheet.
she does?
Yes, Your Honor.
Which one?
It's
Is it out of
for
state?
Tasia Edwards? No, it's a Florida conviction. I believe I put an updated sheet in your pile, Your Honor.
Richardson?
And there was
No,
also,
what's
This is
it?
Edwards, Your Honor.
What did I do with hers? Sorry, because she got shuffled around a little bit. I don't know if I even have her.
I can give you my sheet if you want to look at it quickly, Your Honor.
a prior reckless, a prior resisting.
Yeah, 4/8/2021, last conviction, bad Leo. So it's listed on her face sheet, on this one.
I must have a different face sheet.
And there was also a prior capias on her out on bond as well.
All right. Well, never mind. If you want to plea today, you can plea today, or I can set a bond. I was trying to keep you from becoming a convicted felon, but it looks like you have a prior felony conviction, so.
I was never convicted, from what I remember, so. Yeah, no, I'm not trying to stay here any longer.
So you've heard everything that's going on and the uncertainties and the issues with that potential PTD.
What was that case number? I'm just gonna look it up.
Which one, Your Honor?
The one said the
The one that she's on?
conviction?
Oh, the conviction? I don't have the case number, Your Honor. I'd have to run her history. We just have the last conviction date.
That's what the pretrial
TASIA.
side.
1 second, we're gonna get to the bottom.
Possible that might be the pretrial diversion case. I apologize. I'm going to look into it myself, Your Honor.
Yeah, we just want to get it right. You're welcome.
The only previous things that I pull up for her,
I got 2020 CF 14610.
that is her PTD case.
I believe,
But yeah, there may be another one. That's the PTD case.
I have a 18 reckless driving adjudication. I have an 18 resisting without and reckless driving withhold. She had an 18 battery that was no prost.
May not have been in this county, too.
That's, I'm checking, I'm on CCIS.
Okay.
I should have Florida, but I don't know if she's ever lived out of state.
I think there was something that resolved that started as a felony, but then was downfiled, so I don't know if that's what we're seeing.
That was a possession, right?
I'm
Resisting
running her in just quickly too.
There was a case, 18 CF 12431. That was a felony that ended up resolving as a resisting without reckless. That's probably what it is. I don't know what that case came in as, though. 1 second.
But what's the date of the conviction?
On,
Roll on the face sheet?
April 8th, 2021.
Is that when she took PTD?
All right.
Your
Just
Honor,
to be safe. Yeah, go ahead.
I was gonna say that April 8th is when she took the PTD offer, according to the clerk of court site.
Oh, so that may be what.
It says, looking from what I'm seeing, the case, yeah, defendant was referred to pretrial diversion on 4/8/2021.
Okay, then
Yeah.
that makes sense. All right, so I'm gonna ROR you on the resisting without. I've appointed the Office of the Public Defender to represent you in this case. You're gonna wanna you're gonna wanna contact them as soon as you get out of here and let them know what's going on, especially given your status in diversion, on the felony case. So, and then I'll just admonish you, like I said, it appears from, if you're not a convicted felon, you know, becoming a convicted felon shuts a lot of doors, you're still relatively young, makes life a lot harder for you going forward. So while you're in the diversion program, it's very important that you keep stay out of trouble, stay away from people who get into trouble, because if you're around it, you get caught up in all that, and then you get kicked out of diversion, and then there's a chance you do become a convicted felon, makes it harder for you to get a loan, rent an apartment, go to school, essentially exist in this country if you're a convicted felon, okay? So, you gotta be thinking long-term. All right, good luck, ma'am.
Stay in touch with your attorney. I would call them as soon as possible, he said, because the other case is gonna be taken back. Okay, thank you. Good luck.
All right, sir, your name?
Marcus Richardson.
All right, Mr. Richardson, you're here on one count of trespass, refusal to leave. 2023 MM2180AO. Is there an offer in this case?
there was an offer to resolve, Your Honor, an adjudication, 7 days OCJ with credit for 2, and no return to Walt Disney Properties. The reason for the 7 days is the March 3rd, 2023 trespass
Yeah,
was at the same location, and you received 4 days.
okay.
And Your Honor, Ms. George did have competency concerns. I haven't had an opportunity to personally speak with him.
I understand. If there's concerns, we're not gonna do it today. I'm gonna stay the bond, well, I'm gonna stay the bond at $500. I'm gonna order that you do not return to any Walt Disney World property. You're also out on bond for a trespass at a Walmart. We're gonna take no action on that one, okay? I'll appoint the Office of the Public Defender to represent you. Good luck, sir. All right,
This is a credit time served offer.
all right. Well, we'll reset Mr. Stork for tomorrow. Who's ever here tomorrow, tell Judge Craner not to send me a nasty email. All right, Acosta bonded. All right, sir, your name?
Tracy Shaw.
All All right, Mr. Charles, you're here for a warrant for a failure to appear for 2 counts of petty theft. The bond on the warrant is $500 as to each count.
And state did convey an offer to Mr. Charles of an adjudication, credit for time served, and no return to Famous Footwear at 5580 International and Yuck Skate Shop at 5534 International. And cost of investigation is $236.76 to OPD.
All right. We have the opportunity to speak about that with Mr. Charles. Did the attorney talk with you about that back there?
No, Your Honor.
All right. All right, so the state's offer to resolve your case that you failed to appear on is that you enter a plea of no contest to each count, be adjudicated guilty as to each count, sentenced to credit time served, and that you do not return to the Famous Footwear or the skate shop where these thefts were alleged to have occurred. There's also court costs. You have the right to go to trial on these offenses. You have all the rights associated with going to trial, like the right to an attorney, right to call witnesses, right to confront the state's evidence, have the state prove the charges against you to a jury beyond a reasonable doubt. If you resolve your case here today, you'll be waiving those rights, and there's not gonna be a trial. So, or you can maintain, you have bonds on this, so you have 500 on each count. You don't have to resolve it today, but if you want to, you can. If you don't, you can bond out. You'll get a court date in the future. What would you like to do? You have the right to an attorney either way, so if you want to,
If you want more time to think about it, you don't have to take the offer today, but this is the offer for today. Do you understand the rights you're giving up and what that all entails? And this is just to resolve this case, so if you have anything else going on. Your Honor, he's informed me that he does wish to take the offer to
all
resolve.
right, there's a plea form right there on the table, right in front of you, okay? The top of that plea form, do you read and understand English?
Yes.
All right. So the top of the plea form talks about all those rights we were talking about, the right to an attorney, call witnesses, all that. And it says, by signing that plea form, you're saying you understand that by resolving your case here today, you're giving up those rights. You understand that? Do you understand that? All right. I see you shaking your head, just everything is being recorded, so I have to ask that you answer yes or no into the microphone because the record of everything that's going on here today is being made. So, sir, how far did you go in school? Huh?
12th grade.
All right. How you feeling today? Hearing any voices? Anybody talking to you? Anything like that? All right. You ever hear voices in the past? No? You ever think TV's talking to you or anything like that? All right. You currently taking any medication?
No.
No? Have you ever been prescribed medication for any mental illness, anything like that?
No.
No? All right. Do you understand everything that's happening here today?
Yes, sir.
All right. What are you charged with?
Petty theft?
All right. You know how many counts of petty theft?
2.
All right. All right. You on probation for any other offense?
No.
You understand that by entering a plea to a theft offense, that any subsequent theft charge may be enhanced based on prior convictions? Do you understand that?
Yes, sir.
All right. You still want to resolve your case here today?
Yes, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
All right. All right. We'll accept the no contest plea. How much time, sir, is he on?
I have 2 days.
On the failure to appear?
He has a
I guess it was a notice to appear initially.
That's what
All right. Whatever it is, you're gonna get credit for it. We'll adjudicate you guilty, sentence you to,
KPS for drugs.
who's that?
Mr.
Listen.
Charles, I believe.
He's got a warrant?
I believe he has an open KPS from 3-4 days ago.
Yeah.
So if he were walking out, he potentially would be.
All
I
right.
don't know if they have a hold or.
Do you have that pretrial? Yeah.
We don't have a hold for it. It might not have gotten to warrants yet.
I have it in 22 CF 11298. Was a failure to appear at trial management in front of Judge Navarro.
What's that charge?
Possession of dimethylpentalone.
What was the case number again?
22 CF 011298. AO.
All right, sir, what's going on is there might be a warrant for a failure to appear in a separate case, all right? A felony case, a possession case. If that's the case, I'm assuming that bond's probably set at none.
It is. It's set at none.
So he's not gonna get out.
Well, there is no hold for it yet, so if it hasn't gotten to warrants, we can't put a hold on for him, but we can certainly look into it.
Your Honor, I'll let his attorney know so that they can communicate about what needs to be done.
All right. All right. So he has an attorney on that case?
Yes, Your Honor.
All right, sir, you're gonna need to call your attorney. If you do get out of here today, we can still take the plea if that's what you wanna do. But there's a chance that you're not gonna be released today because there's a warrant in that felony case, all right? And even if you are released today, that warrant's still outstanding. You get picked up, it's been brought to our attention that there's no bond on that warrant, so you're probably gonna wanna talk to your attorney in that case as soon as you get out of here, if you do get out of here, okay? All right. All right, so to the petty thefts, we'll accept the no contest plea. It's to each count, we'll adjudicate you guilty. Order that you do not return, well, sentence you to, is it 2 days? 2 days in the Orange County Jail with credit for 2 days' time served. As to each count to run concurrent with each other. Also, on count 1, we order that you do not return to 5580 International Drive. Count 2, we'll order that you do not return to 5534 International Drive. Court costs and costs of investigation are $236.76 to the Orange County, or to the Orlando Police Department. Plus the court costs, I'll give you 1 year from the date of your release, whenever that may be, to take care of the financial obligations. Otherwise, there's gonna be a suspension on your driver's license, all right? All right, good luck, sir.
Good luck.
All right, so your name?
Ronnie Lee Pruitt.
Stinson bonded? Oh, I'm sorry. All right, Mr. Pruitt, this is 2022 MM8450AO. It's a failure to appear for a petty theft in that case.
State did give me an offer to Mr. Pruitt of an adjudication credit, no return to the 7-Eleven at 49999 West Oak Ridge Road, and cost investigation to OPD in the amount of $112.
All right, we accepting that offer, or we, you wanna stay the bond? What do you wanna do?
Yeah, it's time, sir.
Yeah.
Yeah, I'm accept this, sir.
All right. So you understand, there's a plea form right there. We'll go over it real quick. Top of the plea form talks about all the rights you have. This is a second-degree misdemeanor. Maximum penalty, 60 days in jail, 6 months probation, $500 fine, any combination of the three. You have rights by being charged with a criminal offense. You have certain constitutional rights, including the right to an attorney, the right to go to trial, right to call witnesses, confront the state's evidence, have the state prove the charges against you. By resolving your case here today, you understand you're giving up all those rights?
Yes, sir.
All right. You understand that this, by entering a plea to a theft offense, that any subsequent theft, arrest, or charges can be enhanced based on the prior conviction? Do you understand that? All right. Yeah, do you understand that if you're on probation for a separate offense, a plea to that offense, a plea to this offense might be used to violate that probation?
Yes, sir.
You understand that if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Sir.
Anyone threaten you or coerce you to enter this plea?
No, sir.
All right, well, accept the no contest plea. We'll adjudicate you guilty, sentence you to, how many, how much time?
3 days, Judge.
All right, sent you to 3 days in the Orange County Jail with credit for the 3 days that you already served. You'll be released as it relates to this charge today. You also be ordered not to return to 4999 West Oak Ridge Road, that's the 7-Eleven. Can't go back there. There's also court costs and cost of investigation of $112 to the Orlando Police Department. Give you 1 year from the date of your release to take care of the financial obligations, otherwise the clerk's gonna suspend your driver's license, all right?
Yes, sir.
All right, good luck, sir. All right.
I believe
And state's gonna announce a null pros.
All right, 2014, 2014 MM1416 AW, state announced the null pros.
Yes, Judge.
All right,
And I'm following it up with the clerk right now.
all right, thank you. Almost. All right, sir, your name? Oh, okay. Diaz bonded.
Christian Ayala.
Angel Roblero
Yeah.
hold on.
bonded. All right, we're getting there. A couple of these people bonded out, so we're getting to you, sir. Barrios Ayala, that's you? Okay. All right, you got two cases, 2023 CT 2226 and 2227 AO. One counts DUI, property damage. One counts operating a motor vehicle without a valid driver's license. I reviewed the arrest affidavit, do determine there's probable cause as to each case. I'll appoint the Office of the Public Defender to represent you on each case. We'll stay the bond on 2226 at 1,000 on count one, 1,000 on count two, or it's not two counts, 222. Yeah, so we'll stay the bonds in each case. It's two separate case numbers. The Public Defender's Office is appointed to represent you as a condition of your bond too. I'll order that you do not operate a motor vehicle without a valid driver's license, okay? All right, good luck, sir. All right, sir, your name? Chev, oh,
Shavir bonded, Your Honor.
all right, Shavir, both his cases, he bonded. Yep.
Jason Martin.
Good job, everyone. All right. Mr. Santana?
Yes.
All right, 2023 CT 378 AO. It's one count of operating a motor vehicle without a valid driver's license. A warrant was issued for a failure to appear at pretrial conference. Bond was set at $150. You also have a warrant in. Is that out of state?
It's a fugitive warrant.
It's a what?
It's a fugitive.
Yeah.
That's just-
All right, you also have a fugitive warrant.
I'm trying to see what state it is.
Is it New Hampshire?
Yeah.
Yeah, yes, New
New
Hampshire.
Hampshire. You also have a warrant out of New Hampshire. The bond in that warrant set at none, so you're gonna be held on that warrant until further proceedings, all right?
Your Honor, we do have an offer to resolve the traffic case.
You wanna do that now?
State has an offer on the no valid of an adjudication and credit.
All right, if you wanna resolve your driver's license case, it's an adjudication of guilt, credit time served. Is that what you wanna do? You're still gonna be held pursuant to the New Hampshire warrant, but you wanna resolve?
this.
All right. So you understand it's a criminal offense, you're entering a plea to a criminal traffic offense. You have certain rights because it's a criminal offense, constitutional rights, like the right to an attorney, the right to go to trial, all that, right to call witnesses. And by resolving your case here today, there's not gonna be a trial, and you're waiving all the constitutional rights associated with going to trial. You understand that?
Yes.
Including your right to an attorney. You understand you're waiving that right?
Yes.
All right. Yeah, are you on probation for any other offense?
Nothing.
All right, you understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes.
Do you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, A plea to this offense could subject you to involuntary civil commitment?
Yes.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No.
Anyone threaten you or coerce you to enter this plea?
No.
All right. We'll accept the no contest plea. We'll adjudicate you guilty. What's he got, 2 days?
Yes, Judge.
Sentence you 2 days in the Orange County Jail with credit for 2 days' time served. It's also mandatory court costs, be about $301. I'll give you 1 year from the date of your release from custody to take care of the financial obligations. Otherwise, there's going to be a suspension on your driver's license, all right?
Understood.
All right, you have 30 days to appeal the judgment and sentence. Good luck to you, sir.
Thank you very much.
Uh-huh. All right, sir, your name? All right, sir, this is 2023 CF 4077AO. It's 1 count of possession of MDMA. Reviewed the arrest affidavit. Do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'm gonna stay the bond at $1,000, okay?
He did qualify for PTR, Your Honor.
Oh, sorry. You do qualify for what's called pretrial release, okay? So you're gonna be able to, you're gonna be released as it relates to this case without having to post a bond. So we'll release you on pretrial release. The Office of Public Defender's been appointed, so, you're gonna be released as it relates to this charge today, okay?
And any conditions with it, Your Honor?
Do not possess or consume any illegal drugs without a valid prescription, okay? All right, good luck.
Police officer, they're gonna have certain things you need to do and report. Okay, stay in touch. It'll get revoked. With you, good luck. Also, talk to your public defender, your attorney as well.
All right. 2023 CF 4073AO. Review the arrest affidavit. Do determine there's probable cause. I'll appoint the Office of the Public Defender to represent him. I'll stay the bonds on counts 1 through 6 as they are. 1,000 count 1, 150 on counts 2 and 3, 100 on counts 4 and 5, and 150 on count 6. All right. Your name?
Keith Blackman.
All right, Mr. Blackman, this is 2023 CF 4074AO. 1
Your
count of carjacking.
I was just gonna say defense does have a PC argument.
As to which count?
The carjacking, we'd be arguing that it was an attempt, not an actual completion of, or alleged completion of it. My understanding of the statute is that there has to be an actual taking, and it does not seem, the allegations support that.
Your Honor, state would argue that the jury instruction, number one, that the defendant took a motor vehicle from the person or the custody of the person. State would argue that the defendant took it from the custody of the alleged victim as he pulled her out of the vehicle and got into the driver's seat. The second is by force, violence, or assault, or putting in fear during that taking. State would argue it was by force and violence and fear. And then the third element, it was with the intent to temporarily or permanently deprive them for the benefit of themselves. They would again argue that it is present within this affidavit. As he stated, I believe when law enforcement spoke to Mr. Blackman, that he was being chased by people, he threw a brick through the window of the vehicle because he needed to get the vehicle and get away. So they would argue that there was the intent to temporarily or permanently deprive the victim of the motor vehicle.
All right, I understand the argument. I am gonna find probable causes to count 1. Is he entitled to it? He is entitled to a bond on count 1.
Given that it's, yes, there was no deadly weapon, so he is entitled to a bond.
All right, find probable causes to count 1, 2, 3, 4, and 5. What are we gonna say as it relates to the amount of bond?
Your Honor, state would just bring to your attention that the alleged victim was 85 years old.
Right.
And we just ask that you take that into account when setting his bond. He is entitled to bond on all 5 counts. I do believe Mr. Blackman does have a fairly lengthy criminal history of other violent offenses as well.
Yeah, based on the facts of this case, the prior violent history, prior failures to appear, set bond on count 1 at $80,000. no contact with the alleged victim, no weapons, firearms, or ammunition. Count 2, I'm gonna stay the bond at 10,000. Count 3, stay the bond at 2,500. Count 4 and 5 will stay the bonds at 250 and 500 on those respectfully as well. Appoint the Office of the Public Defender to represent you. Good luck, sir. All right, sir, your name? All right, Mr. Buckner, this is 2023 CF 4067AO. It's one count of aggravated assault with a deadly weapon, one count of resisting an officer without violence. I reviewed the arrest affidavit. I do determine there's probable cause. I'm gonna stay the bond on count 1 at $2,500, count 2 at $500. I'm also gonna order that you have no contact with the alleged victim and that you do not possess any weapons, firearms, or ammunition, okay? I'll appoint the Office of the Public Defender to represent you, but your bonds are what they are. In addition, you're gonna have no contact with the alleged victim, okay? All right, good luck, sir.
So the allegation, so you're gonna have to talk to your attorney in order to get more detail, and that's your bond, okay?
Hold on one second. Hold on one second, Mr. Buckner, hold on.
Your Honor,
You need to go back one time.
it just appears that he has no history, and he's unable to afford the bond. We'd be asking, I don't think he qualifies for PTR, but we would be asking for a lower bond considering the lack of history.
I considered the lack of history and state them accordingly. I'm not, in order to get a lower bond, the motion needs to be filed. We need to get some testimony.
You believe he potentially needs a one-time?
Right.
Victim
So
and
this is
witness
roommate?
roommates?
Yeah, all right. So I also have to order that you maintain separate residences from the alleged victim. If you need to go back to that residence one time, you may do so with the presence of law enforcement to get any personal belongings you need. Otherwise, you and the alleged victim, you can't be roommates until further order of the court.
You have to call law enforcement first, okay? Did you have a question?
Yes,
Just maintain separate residences.
I'll be homeless. I have nowhere else to go.
And
I understand, sir, and these things aren't always clean. There's no perfect solution. That's what I'm required to do by law, so order what, so, I could, wish you the best of luck. You have an attorney appointed. If you need those conditions modified, you just need to contact your attorney, and then they can file the appropriate motions and have it set in the appropriate court, okay? All right. Good luck, sir. Yeah. Oh, did I give you Chevy? I may have accidentally given you him. Next one I have is Cologne. Yeah. I didn't have Chevy.
I have that one.
Chevy,
Yeah.
but he bonded?
He's before Coleman.
All right, if we find him, he bonded. All right. Cologne bonded, so next we have Daughtry. She bonded. Dickerson. All right. 2023 CF 4061AO. Attempted burglary of a structure. I'll appoint the Office of the Public Defender to represent her. Review the arrest affidavit, do find there's probable cause. Has the 23 CF 1764AO been filed on?
It has not.
All right. I'll take no action on that one at this time since it hasn't been filed on.
I'm sorry, I missed.
The bond,
Yeah.
bond on the current case?
Oh, State it, I thought. Sorry, if I didn't say that, I said it in my head. We'll stay the bond at $3,500, no return, and no contact with the alleged victim. No weapons, firearms, or ammunition. All right. Next is Garcia.
And Your Honor, this is the one
Right.
Steve brought up before. I believe it should be resisting without.
She here? Well, she blew it. It's okay, good for her.
Happier to be out anyway.
Yeah, I'm sure. All right, sir, your name?
Stephon Gibson.
All right, Mr. Gibson, you're here pursuant to a warrant. Count one in the warrant was set at, the bond was set at $2,500. We'll stay the bond at $2,500 and just require you to report and register as required within 72 hours of your release, okay?
Yes, sir, Your Honor, but, when I went to register in October of 2021.
Wait, is
Hold on.
it,
Just anything you say can and will be used against you. So I will appoint the Office of the Public Defender to represent you. The judge who signed the warrant already found probable cause, so we're just setting the bond at $2,500. Any defense you may have to this there's a time and place to raise that. Today's not really the day, it's just first appearance. So we're gonna stay the bond. If you bond out, the only thing I'm requiring you to do is report as required within 72 hours, all right, of your release. All right, good luck. All right, your name?
Demogeny Hayes.
All right, Ms. Hayes. It's one count of aggravated assault with a firearm, one count of carrying a concealed firearm, one count of grand theft third degree. Viewed the arrest affidavit, I do determine there's probable cause as to each count. I'll appoint the Office of the Public Defender to represent you. One second. Is there two? Okay. All right, based on lack of history, I'm gonna set bond on count one at $3,500. Count two at $250, count three at $250. I'm gonna order that you have no contact with the alleged victim, that you possess no weapons, firearms, or ammunition, and that you have no contact with the alleged co-defendant, Shaw McKenzie.
Yes, sir.
All right, you violate any of those conditions of release, there's gonna be a warrant issued, and it's gonna be a no bond warrant. You'll stay no bond till you see the judge, okay?
Yes, sir.
All right, good luck.
Thank you. Thank you.
All right, ma'am, your name?
Jackson.
All right, Ms. Jackson, you're here, one count of petty theft with two or more prior convictions in case 23 CF 4060AO. I'll appoint the Office of the Public Defender to represent you in that case. I have reviewed the arrest affidavit, do determine there's probable cause. We'll stay the bond in that case at $1,000 and also order that you do not return to the Millennium Mall.
Yes, sir.
You also have violation of probation warrants. Is it 2 or 3 cases?
It's two violation of probation warrants.
One from Alachua and one from St. John's. All right. So you have violation of probation warrants one from Alachua County, one from St. John's County. Both those warrants have no bond. We're gonna stay the bonds at none until those counties come get you, okay?
Yes, sir.
All right, good luck. All right, Ms. Kinsey, 2023 CF 4065AO. One count possession of cocaine, one count possession of drug paraphernalia. Viewed the arrest affidavit, do determine it was probable cause. I'll appoint the Office of the Public Defender to represent her. Has the other case been filed on?
No.
No? Okay. I'll take no action on that case for now.
Why you gonna stay the bonds?
Oh, that's not, it must be Friday. All right. Yeah, stay the bond on count one and count two, 1,100. All right.
Ray Knight on it, Your Honor.
All right.
Lewis refused.
All right. Mr. Lewis is here in 2023 CF 4087. This was a weird one. Arson second degree of a vehicle and criminal mischief less than $1,000, which is weird. I think they hit the wrong button.
Hang tight, because we're addressing another case and I need to listen.
Viewed the arrest affidavit, do determine there's probable cause, I'll appoint the office of the public defender to represent Mr. Lewis. He's also out on bond. That case has been filed on in 2022 CF 14239 AO. We're going to revoke bond in that case, set bond at none. He has an attorney in that case. So.
The bond is on the new.
Golly.
Any conditions?
What the heck? Yeah, we'll stay him $2,500 on count one, $150 on count two.
And so it would ask for no return to Sky House and.
Oh, yes,
no
yes,
contact.
definitely no return to, yes. No return to Sky House and no contact with any of the alleged victims. All right, sir, your name?
Terrell Jamarvis Lewis.
All right, Mr. Lewis, you have 3 cases, I believe. There are warrants for failure to appear. First case is 2022 CF 1280 AO. Bond in that warrant's $20,000. We're going to stay the bond at $20,000. The other case is 2022 CT 3417 AO. The bond in that case is for failure to appear is $500. We're going to stay the bond at $500. You also have one out of Brevard County. Case number in Brevard County is 2021 CF 35564 AO. That's a VOP warrant. The bond in that warrant set at none. We're going to stay the bond at none. All right, good luck, sir. I'll appoint the Office of the Public Defender to represent you in each of those cases if I didn't already.
So you'll have to talk to your attorney about that. To talk to, because they'll have to do a bond motion and all that.
All right, good luck.
Take this with you, though.
All right, sir, yeah. Sir, your name?
Roland Lopez.
All right, Mr. Lopez. This is 2023 CF 4042 AO. I'll appoint the Office of the Public Defender to represent you in this case. I've reviewed the arrest affidavits, 1 count of false imprisonment, 1 count of battery. I do determine there's probable causes to each count. Hold on 1 second. All right, I'm gonna stay the bond on count 1 at $3,000, stay the bond on count 2 at $500 in order that you have no contact with the alleged victim in this case. No contact means no contact. That's not just physical contact, that's emails, text messages, internet, IMs, 4chan, 8chan, whatever it may be. No communication through third parties, no relaying messages through people, no contact means no contact, okay? Also gonna order that you possess no weapons, firearms, or ammunition, all right? Good luck to you, sir.
It's with you.
Gia refused, Your Honor.
All right, it's 2023 CF 4076 AO. 1 count of possession of MDMA. Reviewed the arrest affidavit, do determine there's probable cause. He also has 23 MO 435 AO. I didn't see that one until now, so give me a second. It's 1 count of,
I apologize. What was that?
it's an open container. It's
Okay.
MO.
I did see that one.
Yeah. There's no allegations in the open container that there was anything, it just says it was an open can of beer. It doesn't say there's anything in it that I can see. Unless I'm missing it.
Your Honor, it just says open can of beer, that it was Earthquake beer, 10% alcohol.
Right. You know, he could have been collecting cans. I don't know. But anyway, I'm a ROR, find no PC as the open container. There's no allegation that there was any alcoholic beverage within the container, just that it was an open can. So we're ROR as to the open container, but we'll stay the bond on the CF 4076 at $1,000, and then that's gonna be it.
He has an
Then
open
he's out on
case.
bond,
Yeah, it's out on ROR.
out on it says ROR in 23 CF 887 AO.
That's
Yeah.
correct, Your Honor.
Oh, I see ROR there. Is that probably because it hadn't been filed on?
It has been filed.
It has?
When was it filed?
It was filed February 28th. It was ROR due to notice
33
of
day.
non-filing on the 20th, and we filed the 28th.
If Your Honor is inclined to take any action, of course, defense would prefer no action, but if you are inclined, we'd ask for revoke and double instead of no bond.
Yeah, all right. Yeah, I'm not gonna set it at none. I am gonna revoke the bond. I'm gonna set bond in that case. It's burglary of a structure. I'm gonna set bond at $5,000 in that case with the condition, no return, no contact.
There's
And the second
two
count, Your Honor?
Petty theft will, set
We-
bond at 100. Yeah, so on the one he's out on bond, 23 CF 887 AO, we're gonna revoke ROR, set bond on count one at 5,100 on the petty theft, and no return, no contact. 1,000, state it. ROR, no PC. Sean Manning, that name sounds familiar too. 23 CF 4071 AO. It's possession of MDMA. I reviewed the arrest affidavit. Due to determine there's probable cause, I'll appoint the Office of the Public Defender, stay the bond at $1,000, and I think this one's, no. All right, we'll just do that.
This one's you.
All right, sir, your name?
Philip Jason Rivers.
All right, Mr. Rivers, you're here on a warrant. In 2022 6 warrants. First one's 2022 CF 2577 AO. 2 counts, 1 count petty, both of them petty theft with 2 prior convictions. Bond on each count is set at $2,500. We're gonna stay the bonds in that case. Or that do not return to the scene where this was alleged to have occurred, no contact with any alleged victim. Next case is 2022 CF 3241 AO. It's 1 count of petty theft with 2 prior convictions. Bond in that case was set at $1,000. Gonna stay the bond with the same conditions, do not return, no contact with any alleged victims. It's also 2022 CF 2073 AO. It's again, petty theft, 2 prior convictions. Bond in that case is set at $1,000. No contact with the victim, no contact with witnesses, and do not return to the scene. 2022 CF 5718 AO. It's another warrant for petty theft, 2 prior convictions. Bond was set at $500 in that case. Also going to order that you have no contact with any of the alleged victims. You do not return to the scene. And then there's also 2022 CF 5719, another count of petty theft, 2 prior convictions. Bond in that case is set at $500. Stay the bond, no contact, no return. Then also 2022 CF 8097. It's a warrant for petty theft, 2 prior convictions. Bond in that case was set at $2,500. Do not return, no contact with any victim, co-defendant, or witnesses. I'll appoint the Office of the Public Defender to represent you in each of those cases, but those are gonna be your bonds, okay?
Your Honor, Mr. Rivers has limited funds right now. He has been incarcerated and unable to, of course, due to that incarceration, have gainful employment at that time and finances for these bonds. I understand these bonds were pursuant to a warrant. However, we would be seeing if the court would be inclined to lower the bonds.
No, absolutely not.
Understood.
Good luck, sir.
Good luck. Talk to your attorney.
Arterio Ruiz, refuse, Your Honor.
All right. 2022 CF 5866AO. It's one count of attempted second-degree murder. I reviewed the affidavit to issue the warrant. Give me 1 second to look at his face sheet. Does the state have a position as to an appropriate bond? Let me look.
Defense would ask, apologies, defense will hold.
Okay, if you, go ahead if you want to say something.
Defense was just going to ask, based on the limited convictions, to take that into consideration,
Yeah,
or the no convictions, I should say.
he's got some out-of-state
Oh, okay,
convictions.
the limited convictions.
Yes.
And Your Honor, state would just, it is an F1, he is entitled to bond. But the allegations within the affidavit are
Yeah, not great.
concerning. And given he has, it seems, extensive ties to out-of-state. His
Yep.
last conviction was out-of-state 29 days ago. So state is concerned that he potentially would be a flight risk, as he appears to have all out-of-state history and has pled to something or was convicted, I'm not sure, out-of-state extremely recently. So state would just ask that you take that into account when setting his bond.
Yeah, based on the allegations in the affidavit, the conduct in the affidavit, and the out-of-state ties, he's got most, if not all of his history is out-of-state. I'm gonna set bond on count one at $250,000. No contact. No return. And no weapons, firearms, or ammunition.
Jalen Thomas bonded.
All right, sir, your name?
Is right?
All right, Mr. Wright, you're here
And
on
defense
a
does.
couple cases. Yeah, go ahead. We'll start with 2023 CF 4038AO, it's possession of cocaine. Defense?
Yes, Your Honor, defense would be arguing for lack of probable cause. I understand the argument of constructive possession. However, I don't believe the police report even states where specifically in the vehicle the substance was found. The first substance, which was, I believe, for the co-defendant, was found in her purse. Then for this one, it just says that something else was found in the vehicle, and please correct me if I am wrong in my reading. But the defense's understanding is that it was found in the vehicle, the location was not disclosed, therefore there's no probable cause to constructive possession, because it could have been in the trunk for all we know.
What says in, while
Wasn't.
searching the truck?
Okay, I did miss that, which
This is more
there,
of a Scrivener's error.
there we go. Well, then that would be defense's argument in that sense. PC wouldn't be met for that either.
All right, whose car was it, State?
I believe the defendant was in the passenger seat. I don't believe it states who the vehicle belonged to, but Ashley.
So Ashley was
Ratchford was driving, and Mr. Wright was the passenger.
And then the other, what wasn't found in the trunk was found in her
her
bag, right?
Yes. And then they continued to search the vehicle, found multiple contraband along with burnt cannabis blunts. I believe that's all we have. In the officer's PC statement, he writes that he has PC due to having constructive possession. It was located in the rear of the vehicle with both denying ownership. That was the officer's justification of his PC.
Where does it say that?
That is the last page.
Okay, and the rear vehicle when both denying ownership.
Yes.
Yeah, I just don't think it's articulated well enough. The trunk can mean a lot of things. Like, is it a closed trunk? Is it like an SUV where it's the rear of the vehicle? He says both. He says the trunk and the rear. So. As it relates to that, I'm gonna find no PC as a cocaine possession, so ROR in 2023 CF 4038 AO. But you also are here in 2022 CF 11633 AO. That's pursuant to a warrant for violation of a conditional release condition. That warrant is set at no bond. We're gonna stay the bond at none in that case until you can go see that judge. You're also out on bond on 23, is that the same case?
No, Your Honor, this is
You're also out on bond on 23 CF 1792 AO. That, I'm assuming, hasn't been filed on yet. It was pretty recent.
1792. No, it has not yet been.
All right, so we'll take no action on that one for now. All right?
So you get to talk to your attorney that has the no bond.
All right, good luck, sir.
Good luck.
All right. Is there anything else to address before we adjourn for the weekend?
Nothing from the state.
I don't believe so.
All right, thank you, everyone. All right, Mr. Landers? Sir, your name?
Landers,
First name?
Zach,
All right, Mr. Landers. This is 2023 MM 2138AO. Madam Interpreter, if you're listening, I'm sorry I didn't say thank you. I think she hung up, but thank you if you're out there. It's one count of trespass on property after warning. Or viewed the arrest affidavit, do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. Set bond at $250. Order that you do not return to the Presidente supermarket. Okay?
I apologize, Your Honor.
Oh.
We have a plea here. We have an offer from the state, adjudication of guilt credit for time served.
All right, do you have a chance to go over that with Mr. Landers?
yeah,
So is he accepting that?
Yes, Your Honor, he's going to take that plea.
All right, you got a plea for him?
Yes, Your Honor.
I can't spell.
You understand the plea form? You want to take the plea?
Yeah,
Okay. Do you have any questions about it?
I go home.
When you take that offer, as long as something else is told you, do you have any other questions about the rights you're giving up, anything like that, that Ms. George talked to you about?
All right, sir, your name again?
Zach,
Last name?
Landers,
All right, Mr. Landers. You understand you're charged with trespass on property after warning?
yeah,
It's handed a plea form. Did you sign the bottom of the plea form? Did you sign this form?
yeah,
How far did you go in school?
12th grade,
Yeah. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
no,
You understand that by resolving your case here today, there's not going to be a trial and you're waiving the constitutional rights that are listed at the top of the plea form?
yeah,
You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
yeah,
You understand that if you're on probation, do you understand that if you are on probation, a plea to this offense might be used to violate that probation? All right. Any questions for me before we enter the plea? What's that?
Can I go home?
Yeah, you'll be released as it relates to this charge today. You understand? All right, we'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for the 2 days that you already served.
Your Honor, he's on SSI. I would ask that the fees be reduced to a civil judgment.
No problem.
Thank you.
Adjudicate you guilty, sentence you 2 days in the Orange County Jail with credit for the 2 days that you've already served. Also, the order that you do not return to the Presidente Supermarket on North Pine Hills Road.
You,
Just can't go back there, okay?
okay.
All right, you'll be released as it relates to this charge today. Also have to assess mandatory court costs. We'll reduce those to a civil judgment, okay? All right, good luck to you, sir.
This one is the only one. Said it doesn't have.
We moved her up and she bonded. What? Good for her. Oh, that one, sorry, that one goes with that one. She bonded. All right. 2022 CT 1546 AW, sir, your name?
David Earl.
You were here yesterday, right? Or,
That's it.
no, never mind. Name sounds familiar. What division is this in? Earl? David Earl?
Arraignment docket, 81.
81?
Yes.
That's why it sounds familiar. Okay. All right, 2022 CT 1546 AW, is this a VOP?
Yes,
All right, so it's a violation of probation, DUI with property damage. What are we doing with that one?
Your Honor,
Office of the, Office of the Public Defender's been previously appointed, so what are we doing with that one?
we'll enter denial at this time.
All right,
Case to be heard in Division 81. VOP status is April the 21st at 9 a.m. Courtroom 6B.
all right, good luck to you, sir. When did he get placed on probation? I reckon, that wasn't that long ago, I don't think. I don't, it doesn't matter, he just is, its name's familiar. All right, sir, your name?
Angelo Austin.
All right, Mr. Austin, 2023 MM 2067AO, you're here for an arraignment today. That's a petty theft of $100 or more. The Office of the Public Defender's been previously appointed. What are we doing with that one?
Your Honor, we do have an offer to resolve today, and he does wish to take that.
All right, the CF, was that down, was that
Yes, Your
how it
Honor.
originally, okay. So he's not on probation or anything?
No, I don't believe I would have relayed an offer if he was on
Yeah,
probation.
I'm just making sure. I just saw the CF case number up there, making sure. All right, so what's the offer's time served?
Yes, Your Honor.
Adjudication of guilt, credit for time served. This one also has restitution of $404.69 and cost of investigation of $168.38 to OPD.
168.38?
Yes, Your Honor.
All right, and a no return?
It was outside of a bank, Your Honor.
Okay, all right. All right, sir, you heard what the attorney, your attorney had to say. Is that your understanding what's happening here today?
Yes, sir.
All right, you got a plea form?
Yes,
All
Your
right,
Honor.
that form in front of you is a plea form. There's certain constitutional rights at the top that you'll be waiving by entering a plea today, and then some consequences down at the bottom. Do you have the opportunity to read and understand the plea form?
Yes, sir.
All right, you understand that by resolving your case here today, there's not going to be a trial and that you're waiving those constitutional rights listed at the top of the plea form? Got to answer it out loud, yes or no, because,
Yes.
yeah, I see you shaking your head, but they're making a record, so it's got to be yes or no into the microphone, all right? All right. You understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes.
Do you understand that if you've ever been, that if you're on probation for a separate offense, a plea of this offense might be used to violate that probation?
Yes.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Yes.
Are you, let me ask you again, are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Oh, no, sir.
All right. So I talk fast, I'm sorry, it's my fault, I'm sure. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right, we'll accept the no contest plea. We'll adjudicate you guilty. Well, let me ask you this too, before we do that. You understand that by entering a plea to a theft offense, that any subsequent theft arrest, those charges could be enhanced based on this prior conviction? You understand that?
Yes, sir.
All right. Still want to enter your plea to this offense? Do you still want to go forward with the plea today?
Yes, sir.
All right. All right, so we will accept the no contest plea, adjudicate you guilty, sentence you to 61 days in the Orange County Jail with 61 days.
Your Honor, I
Yeah,
don't
it's
believe
an
he's being
M1.
held on this offense.
Is he?
No, I don't
He's
believe
not.
he is being held
But
on
he
this
still has
offense.
so he doesn't have 61 days.
No, he has closer to 33 days, Your Honor.
So 33 is what you've got?
I believe so because our motion was granted,
I see.
but he wasn't able to be released, but he was not being held on this offense.
I don't know the exact dates, but that sounds correct.
Whatever it is, it's time served, right?
Yes, it is,
Yeah,
it
right,
is a
just want
time
to make
served.
sure we get that right. All right.
Arrested on 21.
All right, so we'll send you 34 days in the Orange County Jail with credit for 34 that you've served on this charge. You'll be released as it relates to this charge today. Also have to assess court costs plus restitution of $404.69, cost of investigation of $168.38 payable to the Orlando Police Department.
The restitution, I don't know who the restitution.
What's it?
The restitution, she gonna give us a form.
Yeah, we need a restitution order.
I will do that, Your Honor. It's an individual, so I need to figure out
Okay.
if, I'm sure I'm not giving an address, so that's why I haven't done the order yet.
All right, so state will provide a restitution order. We'll order the restitution be paid first, but as it relates to all of the financial obligations, we'll give you 1 year from the date of your release to take care of those. Otherwise, the clerk's gonna suspend your driver's license if you haven't paid it in full within a year and you're not on a payment plan making regular payments, okay? All right, good luck to you, sir. You have 30 days to appeal the judgment and sentence.
Good luck with it.
Yeah. All right, sir, your name?
Welcome, Fernan.
All right, Mr. Fernan, this is 2023 MM2054AO. It's set for an in-jail arraignment today. It's 2 counts, 1 count resisting an officer without violence, 1 count of trespass in a structure. What are we doing with that one?
There is an offer to resolve from the state. He wishes to take it, an adjudication of guilt, credit for time served, no return to 709 Brookhaven Drive, cost of investigation of $123.44 to OPD. You can please sign right here.
It was 709 Brookhaven?
Yes.
Any questions? Okay. Take this from you.
Excuse me. All right, Mr. Fernan, handed a plea form. Did you sign the bottom of the plea form? Did you sign the bottom of did you sign the
Yes.
bottom of this form?
Yes, Your Honor.
You understand that by resolving your case here today, there's not gonna be a trial and that you're waiving the constitutional rights that are listed at the top of the plea form?
Yes, sir.
All right. You understand that if you're on probation for a separate offense, a plea of this offense, might be used to violate that probation?
Yes, sir.
All right. Do you understand that if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
Yes, sir.
Hold on. I speak too fast. Let me, are you under the influence?
No, no, no,
Oh,
no,
yeah,
sir.
yeah. No, you're like the third person to do that. It's my fault. It's obviously my fault.
I heard him going home.
Yes, I know. So are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No, sir.
All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right. We'll accept the no contest plea, adjudicate you guilty as to each count, sentence you to 35 days in the Orange County Jail on count one with credit for time served of 35 days. Also order that you do not return to 709 Brookhaven Drive. So I have to assess court costs and cost of investigation of $123.44 to Orlando Police Department. Give you 1 year from the date of your release to take care of the financial obligations or to be on a payment plan making regular payments. Otherwise, the clerk's going to suspend your driver's license. As to count two, we'll also adjudicate you guilty, sentence you to, 14 days. Yeah, 14 on count one. I said, I was looking at a different one. So 14 on count one, 14 on count two, with credit for 14 times served to run concurrent with the sentence in count one. No further sanction. You have 30 days to appeal the judgment and sentence. Anything further? All right. Good luck to you, sir.
Good luck. That's for your record. Okay.
All right, sir, your name?
James Williams.
How old are you?
How old?
Yeah.
21.
All right, just make sure. You got a baby face.
Thank you.
2023, you know, we can't take pleas from people that are under the age of 18, so I just want to make sure that we got all your information right. All right, 2023 MM40AE. Office of the Public Defender has been previously appointed. It's one count trespass in an occupied structure. What are we doing with this one?
Your Honor, there's an offer of a withhold of adjudication, credit for time served, no return, no return to Arbor Apartments, 8636 Villa Point Drive, cost of investigation of $176.23 to Maitland PD, and he wishes to accept that and enter a plea of no contest.
All right. All right, Mr. Williams, you heard what your attorney had to say. Is that your understanding of what's happening here today?
Yes, I think.
All right.
Yes.
All right. So there's a plea form in front of you. On top of that plea form is you're charged with a criminal offense. You understand that?
Yes.
All right. We're going to walk you through it. If you got any questions, just stop me, okay?
Okay.
All right. You're charged with a criminal offense. It's a first-degree misdemeanor. Do you understand the maximum penalty on a first-degree misdemeanor? It's 1 year in the county jail, 1 year probation, a $1,000 fine, or any combination of the three. Do you understand that?
Yes.
All right. You understand your offer is 35 days in the Orange County Jail with credit for the 35 that you've already served? You understand that?
Yes.
All right. You understand you have the right to go to trial on this offense. You have the right to have an attorney. You have the right to an attorney. You have the right to an attorney help you through the trial. You have the right to call your own witnesses, confront the state's evidence, cross-examine the state's witnesses, have the state prove the charges against you beyond and to the exclusion of every reasonable doubt. Do you understand you have those rights?
Yes.
You understand that by resolving your case here today, you're waiving those rights and there's not going to be a trial?
Yes.
All right. You understand that if you're not a U.S. citizen, a plea to this offense could subject you to, or will subject you to deportation?
Yes.
You understand that if you're on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yes.
All right. And you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No.
All right. Anyone threaten you or coerce you to enter this plea?
No.
All right. So that's pretty much the nutshell of what we're doing and what's listed on the plea form. So if you don't have any questions, go ahead and sign the bottom of that plea form. We'll accept the plea, okay?
Right here.
You have an attorney appointed to represent you, so if you do have any questions, you can feel free to ask them. If you don't have any, that's fine too. We'll go ahead and do what we're gonna do, okay?
That's-
Can we just pass
Yeah.
it just for a second? Let me step back and talk to him a little bit more.
All right.
Just wanna make sure he's fully-
Perfect, thank you.
Thank you for that, Your Honor.
Uh-huh.
Actually, he's ready, Your Honor. He just got confused with the credit time. He thought he had to do more time.
Oh. That's good. All right, so. We got, so we're You're good, you're good to go. Attorney, you had your questions, your attorney answered all the questions?
Yes, and one more question.
Yeah.
When I got arrested, I had like luggages.
Mm-hmm.
I got arrested in maintenance, so I go to maintenance to pick up my luggage, like the maintenance police department.
I don't know if they brought it here. If they don't have it here, yeah, you probably need to go to the agency that arrested you, okay?
Okay, thank you.
Uh-huh. All right. So did you sign the bottom, hold on.
Yes, sir.
Sign the bottom of the plea form? Did you sign it? Did we already do it?
Yeah.
No, we already imposed the sentence and everything?
Yeah, you went through everything. It was just a matter of whether or not he understood.
All right. So we did everything. Okay. All these run together, so yeah. Uh-huh, thank you, Mr. Williams. Good luck. All right, sir, your name?
Jasper Alexis.
All right, Mr. Alexis, you are here.
And Your Honor, we do have a probable cause argument on this one.
On the open container?
Yes.
All right,
No objection.
yep.
Thank you.
All right, you're here for one count of, on 2023 MM 2144AO, one count of battery. Reviewed the arrest affidavit as it relates to that case. I do find there is probable cause. I'll appoint the Office of the Public Defender to represent you in that case. I'm going to set bond in that case at $250. Order that you have no contact with the alleged victim.
Thank you.
That you do not return
Nothing else is holding you yet.
to the area of 596 West Church Street.
Thank you, officer.
Yep, hold on. You also have case number 23MO433AO. One count of resisting?
No,
State misdemeanors, what was the misdemeanor?
yeah, I apologize, Your Honor. It's usually a trespass, but yes, in this case, it would be a resisting. I do apologize.
All right, that's fine. All right, I do find probable cause as it relates to the resisting officer without violence. I'll stay the bond on that case, on that count at $250. Was also arrested on a allegation of open container. There is no probable cause that the container was open in violation of the law, so we will ROR you as it relates to that count, okay? You're also out on bond. State have any objection to taking no action on the cases he was out on bond on? They were drug paraphernalia, MDMA. Have they been filed on?
The last two, 22 CF 1090 and 22 CF 14259 have been filed on, Your Honor. The only reason that I hesitate is if it had just been the municipal order, absolutely no problem. But the allegation is that he punched a lady in the face unprovoked,
Don't talk about
Right.
which is not related to
Don't
drugs.
talk about the.
Hold on.
It's okay.
Which is not related to drugs, Your Honor, but he is out on bond and.
I understand. I'm gonna take no action on it. I'm gonna tell you why real quick. Just I understand the allegations. This does, just the quality of the evidence is, it definitely is probable cause, but it is, a lot of he said, she said.
Okay.
So, based on that, we're gonna take no action, okay?
Thank you.
All right,
Thank
good
you,
luck.
Your Honor.
Good
Thank
luck.
you, Your Honor.
Thank you, Your Honor. Have a good one.
I said put it at 250. Yeah, no contact, no return. Yeah. Out on bonds, yeah. All right, 2023 MM 2150, Reed? Is that who refused?
No,
What happened?
What's the booking number you had for Reed?
We got, is attached.
This is Jesper,
Oh, yeah, Reed is after Fitzpatrick.
Patrick, oh, okay. I did it. I'm having a rough time today. Let's look.
It happens to all of us.
Yeah. I got Fitzpatrick. He refused? There's something going on at Epcot yesterday, huh? 2023 MM 21588AO. I'll appoint the Office of the Public Defender to represent Mr. Fitzpatrick. I reviewed the arrest affidavit. Do determine there's probable cause. He's also got holds, right?
Yes, Your Honor.
Out of state.
Get a
It
fugitive.
appears so.
All right. Based on the fact that he has those holds too, we'll set bond in this case. We'll stay it at $1,000. No return to any Disney property. All right. All right, sir, your name?
Water Monty Reed.
All right, Mr. Reed, you're here on one count of trespass on property after warning. Is there an offer to resolve this one?
Yes, Your Honor, the offer is an adjudication of guilt, credit for time served, and he wishes to enter a plea of no contest and accept that offer.
All right. I'm not gonna order him not to return. I think there's already a trespass warning. I just don't want their court order to not return to the hospital.
Your
Is
Honor,
that
that
okay?
wasn't part of the offer.
No return, was it?
It's just
Okay.
an adjudication of guilt, credit for time
Then,
served.
sorry for getting ahead of myself. You guys are all over it. All right. All right, Mr. Reed, you heard what the attorney had to say. Is that your understanding, of what's gonna happen today?
Yes.
All right. So there's a plea form in front of you. You have the opportunity to read and understand the plea form? You ever seen one of those before?
Yes.
All right. So if you don't have any questions about the plea form, go ahead and sign the bottom of the plea form.
When Fitzpatrick, we left the bond.
Yeah.
Okay.
No return to any Disney property.
Mm,
Yeah. Can't be acting like that. Going to Disney. Hanging out with all them kids. All right. So I was handed a plea form. Did you sign the bottom of this plea form? All right. You understand that by resolving your case here today, there's not going to be a trial and that you're waiving the rights associated with going to trial that are listed on the plea form? All right. You understand that if you're on probation for a separate offense, a plea of this offense might be used to violate that probation? Do you understand that?
Yes.
All right. You understand that if you are not a U.S. citizen, a plea of this offense will subject you to deportation? Do you understand that?
Yes.
All right. Anyone threaten you or coerce you to enter this plea?
No.
All right. Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today?
No.
All right. We'll accept the no contest plea. We'll adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. You'll be released as it relates to this charge today. Also, you have to assess mandatory court costs. I'll give you 1 year from the date of your release to take care of the court costs. Otherwise, the clerk's going to suspend your driver's license. All right?
Okay.
All right. Good luck to you, sir. You have 30 days
Two.
to appeal the judgment and sentence.
Good luck.
Other way. There you go. All right, sir, your name?
My name is Sherman Shagan.
All right, Mr. Shagan, you're here in 2023 MM 2157AL.
Oh, Your Honor, and his bond is pending.
All right. All right, so your bond's pending. So, I mean, somebody's paid the bond. You'll probably be released pursuant to that bond. Just, we're gonna stay the bond at $500. I reviewed the arrest affidavit. Do determine there's probable cause. Also, as a condition of your bond, order that you do not return to any Disney property.
That's correct.
All right, good luck, sir.
Stay in touch with our office.
Do you know when my next court date's gonna be?
You don't have one yet.
So here's the deal. Your Honor, his only concern, he's just telling me his concern is, he lives in Seattle, but I've informed him that as long as he stays in touch and shows up for court dates, it should be no issue to return
Right,
home.
all right, and here's the thing too. If you have,
It has to be put in the order.
so you can't go back to any Disney property. If you have stuff that's located at one of the, you can go back one time with the presence of law enforcement to get anything that may be in the hotel or anything like that, okay?
All right.
All right, good luck.
Your Honor, could it just be a part of his conditions of release that he's allowed to return? I guess there were some issues before. We just like to make sure there's no issue.
Yeah, he can return to Seattle. There's no, court has no objection.
And Your Honor, just for the record, was the PD appointed or not?
I
don't-
didn't, because someone already paid the bonds.
Okay,
Yeah.
thank you.
I typically appoint them to everyone if they're still in jail.
Okay.
Yeah.
Oh, so he had a bond.
Mm-hmm.
So we don't have to put on that original. Oh, you said what? Put on
It was pending, you know, things happen. So since he was here, we just went ahead and we stayed it at 500 and
Okay, and he can go,
if he needs to, yeah. All right, sir, your name? All right, Mr. Brooks, you're here on a warrant for a failure to appear in case 2021 CT 3282AO. Is there an offer to resolve this one?
Your Honor, there is an offer of a withhold of adjudication credit for time served, which I conveyed to Mr. Brooks. At this time, he'd like more time to consider his case.
Okay. All right, so we'll stay the bond as it came in on the warrant at $2,000, so you have a bond, okay? All right, good luck.
Any questions about that? What just happened?
Was the PD previously appointed? Probably not. If the, I'll appoint the Office of the Public Defender to represent you, okay? All right, good luck.
Just stay in there. If you bond out, stay in touch with our office. Good luck.
I have Kiato Perez.
Not Gabriel Dominguez?
Yeah, that's,
No, I got Gabriel Dominguez after this. I've got Pabel Calado Perez, 230-07973.
you guys don't have, say the booking number one more time, Your Honor.
Yeah, 2300-7973.
They bonded.
All right, bonded. Dominguez bonded. All right, sir, your name?
Alfred Jackson.
All right, Mr. Jackson, you're here on one count driving under the influence. I reviewed the arrest affidavit to determine there's probable cause. I'll appoint the Office of the Public Defender to represent you.
Mr. Jackson has bonded.
What's your name?
Alfred Jackson.
All right, so he's bonded?
Yeah, his bond's already been processed.
All right, so someone paid your bond, you're gonna be processed out, so you're good to go.
Thank you.
All right, good luck.
So with the public, does the public defender know?
No, we're not, yeah,
I mean, his stuff's already closed out. He's like
yeah.
leaving.
So you've already bonded out, all that stuff I just said, act like it never happened. All right,
so he posted bond, we
Yeah,
worried about him.
right.
All right, bond, I put on his bond.
Yeah. All right, sir, your name?
Joshua Sanchez.
All right, Mr. Sanchez, you're here on failure to appear in case 2022-197AE. Is there an offer to resolve this one?
Yes, there is.
All right.
The offer from the state is an adjudication of guilt, credit for time served, and Mr. Sanchez wishes to enter a plea of no contest.
All right, Mr. Sanchez, you heard what the attorney had to say. Is that your understanding what's happening here today?
Yes.
All right, there's a plea form in front of you. If you don't have any questions about the plea form, you can go ahead and sign at the bottom. It just talks about the rights that you have associated with being charged with a criminal offense, including the right to an attorney, the right to trial, all that, and that by entering your plea today, you understand that you're waiving those rights. You understand that?
Sir.
All right. You on probation for any other offense?
Sir.
You understand that if you're on probation for a separate offense, a plea of this offense might be used to violate that probation?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? All right. Anyone threaten you or coerce you to enter this plea?
No, sir.
All right. Do you understand if you're not a U.S. citizen, a plea of this offense will subject you to deportation?
Yes, sir.
All right. We'll accept the no contest plea. We'll adjudicate you guilty, sentence you to credit time served 2 days.
No, he got more than two, I got to calculate.
Joshua Sanchez? Oh, because he had some on the original.
FTA, yeah. Go back to the events. They don't tell me.
Just want to make sure you give you credit for every day that you spend here. You got 2 on the warrant. but you had some original days on the original offense.
Yes, sir.
All right, so we just want to make sure we give you credit for all those.
What about if not enough credit? Would you guys run time served for?
It's time served. You're gonna be released as it relates to this today. I had you down for 2, they got you down for more days than that, so we're gonna make sure we give you credit for every day that you spend in here.
Yes, sir.
Two, you got 2 on this latest arrest. Yeah. All right. So we have you for 53 days. So, because I guess you were in here for a while on on the original arrest. So we sentence you to 53 days with credit for 53 days. So you're gonna be released as it relates to this charge today, okay? All right, they also have to assess court costs. Court costs, I'll give you a year from the date of your release to take care of the court costs, or to be on a payment plan making regular payments. Otherwise, there's gonna be a suspension on your driver's license. So if you ever wanna try to go get a driver's license, you're gonna have to take care of that, okay?
Yes, sir.
All right, good luck. All right. All right, Wetzel bonded. That's Sanchez, that's who just played. All right, your name, ma'am?
Latasha Adams.
All right, ma'am, you're here on 2023 CF 4014AO, one count of trafficking in MDMA with a weapon, one count of possession of cannabis over 20 grams. We know why this came in, no bond, is it?
Technically, Your Honor, it is a PBL, so she's not entitled to a bond. However, if you look at the bond schedule, it does list an amount of 100,000 because of the weapon. Usually it would be 50,000, but with the weapon, it bumps it up to 100,000.
All right. Any objection to setting a bond in this case?
No objection.
All right. All right, I've reviewed the arrest affidavit, do determine there's probable cause as to each count. I'm gonna set bond on count 1 pursuant to the bond schedule at $100,000. Order that you possess no weapons, firearms, or ammunition, that you have no contact with Jerome Sims, Walter Upshaw. Yep. Also appoint the Office of the Public Defender to represent you. All right?
There's a second
What's that?
count.
Oh, we'll stay the bond on the cannabis at 150. All right? Thank you. All right, that's it. Good luck, ma'am. All right, sir, your name?
Jeremiah Birch.
All right, Mr. Birch, you're here on 2023 CF 4017 AO, it's one count of possession of cocaine, one count of possession of MDMA. I've reviewed the arrest affidavit. Do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. Stay the bonds on counts 1 and 2, 1,000 on count 1, 150 on count 2. Is there any,
No, Your Honor, formal charges have not been filed in
Okay.
23 CF 2014.
all right, they haven't filed charges on the case you're out on bond on, but just so you know, if, when you're out on bond and you get picked up on new charges, you're no longer entitled to a bond, okay?
That is true, Your Honor.
All right, so we're gonna take no action on it today, but just understand you're out on bond on 2 cases now. Or if you bond out on this one, you'll be out on bond on 2 cases now. You get picked up again, there's a pretty good chance you'll be held no bond, okay?
Yes, sir.
All right, good luck. All right,
And how much is the bond?
1,000 and 150.
How much it costs to get out?
That's gonna be
I mean, how
between,
much it got altogether, you
You're
know?
gonna have to talk to the bondsman.
I'm asking
The
how
amount
much.
is 1,150, so you'll have to talk to the bondsman. Usually,
Ma'am,
it's usually,
I'm trying to find out the exactly.
hold on, sir,
I'm trying to.
I understand what I'm trying to tell you. We can't tell you the exact amount because that's gonna be between you and a bondsman. It's typically 10%, so
I understand $1,000. What's the one?
we can't tell you the exact amount, sir.
Is that
Listen,
$150?
you have the bonds.
Okay, now I know.
It's typically that, but that's gonna be between you and a bondsman, okay?
You're missing my point.
Good luck.
Thank you for not taking action, Your Honor.
You're welcome. Asking us to do math? The heck? That's where I draw the line. All right, sir, your name?
Anthony Castro, Your Honor.
All right, Mr. Castor, you're here on 2023 CF 3733 AO pursuant to a warrant, so a probable cause determination has been previously made. Possession of cannabis with intent to distribute, possession of THC, possession of a controlled substance, resisting an officer without violence, and giving false information. The bonds pursuant to the warrant are as follows: count 1, $1,000, count 2, 150, count 3, 150, count 4, 150, or count 4, 100, count 5, 100. We'll stay the bonds as it relates to each count as it came in the warrant. We'll appoint the Office of the Public Defender to represent you. You're also out on bond on 3 cases. 2023 CF 3115 AO, burglary of a conveyance. 2023 CF 3116 AO, burglary of a conveyance. 2023 MM 163 AO, petty theft. Have the charges been filed on any of those?
And Your Honor, there's a 4th out on bond.
There's a 4th?
Yeah, it's 2023 CT 001710 AO.
Say it again.
He's out on bond on 4.
23 CT.
Yeah,
Honor.
001710 AO.
Your Honor, formal charges haven't been filed on any of them.
and Your Honor, he is currently working and has gainful employment. If bond were to be revoked on those and charges not filed at this time, we would just ask that no action be taken by the court so that he can continue to work.
All right.
And Your Honor, I just would like to state that I'm not a flight risk to the court at all. I turned myself in once I found out I had these charges pending. Just wanted to let you know that.
Your Honor, do you have a second case pending today, 23 CF 3719? It's a fleeing and attempting to elude. Do you have that one as well?
No, yeah,
He
yeah, I
is
do.
in- yeah. He's in on this as well, but flea attempting.
It's already been,
No, he's.
We're on
That
first
needs to be
appearance on
addressed
that
as
one.
well, yeah.
All right, yeah, there's another warrant in 2020, sorry, I just thumbed over it. 2023 CF 3719 AO. That's one count of fleeing and eluding. Pursuant to a warrant, probable cause determined to be made, has already been made. We're gonna set bond in that case at $2,500. And I'll appoint the Office of the Public Defender to represent you in that case as well. Give me 1 second. All right. Due to the fact that those cases that you're out on bond on have not been filed on, and due to the fact that you did turn yourself in. That's reflected in the arrest affidavit. I'm gonna take no action on those cases you're out on bond on, but understand that you caught a break, all right?
Thank you so much.
So go to work and quit messing around, all right?
So much. Your
Attorney,
Yep.
especially if there's anything involving that, okay? Good luck with everything. And Your Honor, I do have probable cause arguments for this one.
What's this one?
It's
If
the
you-
attempt, I mean, I think there's probable cause for attempt, but not sale. Is that your argument?
What are we talking about?
It's the sale, it's the control, it's the,
No,
it's
which-
2023 CF 4033AO, Edwin Cavellos. It's the
And
phone call.
he's bonded on all of his Orange County cases.
He's just held on the
He's
BOP.
just has the violation of probation out of county.
That's the only thing that I have is just the
Yeah.
VOP.
All right, so he's bonded on the,
He's bonded on all his Orange County cases. He's
all right, so
just,
2023
out of
CF
county.
4033AO, he's bonded.
Okay.
So there's that one. You also have violation of probation from Polk County, 2023-116010. We're gonna set the bond at none on that until Polk, does Polk come in 24 hours on VOPs too? Or is that just when they issue the warrant?
When they're notified, I don't know, I don't do that.
Okay. All right.
I think they have.
So you're on probation in Polk County. Because you're on probation in Polk County, you're gonna have no bond until you can go back to Polk County, okay?
Is there any way, Your Honor, that I can, because from what the lawyer set out, that reviewed the case outside, was that they don't even know I have a BOP. This was by the detective that was here.
Yeah, you're on probation in Polk County.
Yeah, I wanted to see if we can get out and handle that while I'm out.
No, Polk County's gonna come get you, and then you're gonna have to handle that in Polk County. All right? Good luck. I'll appoint the Office of the Public Defender to represent you on that case, though, while you're here, so you don't get stuck over here, okay?
So we've been appointed so we can keep an eye on you, okay? Usually takes about 72 hours.
There's nothing else we can do about that, right?
You'll have to handle that in Polk County. We don't have jurisdiction. It's the Polk County. That's the policy. If they don't pick you up for any reason, then we'd bring you back here and figure something out. But if they have time to pick you up right now, okay?
All right, good luck, sir. All right, sir, your name?
Tommy Counts.
All right, Mr. Counts, you're here for a warrant
Yes, sir.
for a failure to appear. Hold on.
You don't have to say anything.
The judge who signed the warrant set bond at none, so we're gonna stay the bond at none. I'll appoint the Office of the Public Defender to represent you, okay?
Yes.
All right, good luck, sir.
You'll have to talk to your attorney and get in front of the judge who has this. And get bond back, okay? So good luck.
Yeah. Is that Dennis too? Or Jean-Claude Dennis?
Do you have a booking number for Dennis?
I don't have it.
Yeah, 23007944. I bet, I don't know.
Dennis bonded.
Yeah, Dennis bonded. All right, John Doe, refuse? Behavior. All right. 2023 CF 4018AO, 1 count of resisting an officer with violence, 1 count of battery on an officer. Reviewed the arrest affidavit, do determine there's probable cause. I'll appoint the Office of the Public Defender to represent Mr. Doe.
Your Honor, we'd ask if we can reset this one for tomorrow, 24 hours.
Because
Yeah, because,
Your Honor, just because we haven't been able to identify him at this time.
yeah, that's fine. He is who he is. I'm gonna set bond on count 1 at $500, count 2 at $250. The Office of the Public Defender's been appointed to represent him. If, after you ID him, you need to bring him back to anyone, you can do that, but.
Thank you, Your Honor.
Yeah.
So I apologize. Is it reset to tomorrow or
No.
no? Okay, thank you.
Yeah, but no, behavior.
Behavior.
Yeah. All right, ma'am, your name?
Ariel Dumont.
All right, Ms. Dumont, you're here on 2023 CF 3260AO pursuant to a warrant. Count one's larceny, retail theft. Count two is petty theft of $100 or more. The bond in the warrant, count one is $3,500, count two, $1,000. We're going to stay the bond as they are. Also, do not return to any Target store. Doesn't qualify for PTR, right?
It was ordered drug testing through PTR, Your Honor.
And we can do that?
Yes.
All right, so we'll order or drug testing through PTR. And she's got a couple cases, right?
When you want that to start?
Or is it just the one? It's just the one?
She has three, she's in on three cases.
We can, the urinalysis,
Want to start at so many business names or?
let me think. We can start it in 14 days. All right, you're also here on 2023 CF 3261AO is another warrant. Same counts, count one, larceny, retail theft, count two, petty theft of $100 or more. Count one, bonded $3,500, count two, $1,000. We'll stay the bond, same conditions, no return to any Target store. Random urinalysis through pretrial release. To begin within 14 days of your release. And then there's 2023 CF 3259. Also pursuant to a warrant, grand theft third degree, count two, larceny, retail theft. Count one, and that warrant was set at $20,000. Count two at $5,000. We're gonna stay the bonds on count one and count two as they are in the warrant. Also, same conditions, no return to any Target store. PTR, random urinalysis through PTR to begin within 14 days of your release. I'll appoint the Office of the Public Defender to represent you in each case, okay? All right, good luck, ma'am.
Take this, stay in touch.
Hi, Felicia. All right. All right, ma'am, your name?
Ariana Fox.
All right, Ms. Fox.
And Your Honor, I do have some probable cause arguments for this one.
On the alprazolam?
No objection.
Yeah.
Additionally, I do have another argument that I,
Yeah, go. All right. So I'll appoint the Office of the Public Defender to represent you in 2023 CF 4009AO. Counsel, what's the argument as it relates to count one or three?
the court correctly and the state identified the alprazolam as our first argument. The second argument, if the court is willing to entertain it, we'd be arguing that there's lack of probable cause as well for the fentanyl charge. I understand that the state will argue that it's a Scrivener error, but if you read the report, there's actually nothing that mentions fentanyl. The officer has 16 years of experience and talks about that experience, but throughout the whole entire report, the only thing mentioned is fentanyl, and he says it continuously, and I just believe that that is not probable cause, as nothing is stated that there was any presumptive positive for fentanyl or that any suspected fentanyl was found. These are legal documents that are relied upon.
I know. You know, I mean, we are limited to the four corners. Say you want 24 hours? I mean,
For him to spell this correctly, Your Honor?
listen, when she first said it, thought, yeah, nice try, but I mean, we identify everything else, we need presumptive positives, it's, as silly as it is, I don't think that this document is probable cause that she possessed fentanyl. It's Fontanelle. And the analogy that my brain used, you know, like, you got a Gucci bag with one C. That ain't a Gucci bag. That's a, you know, maybe maybe Fontanelle's a real thing. I don't think it is, but
Okay,
yeah, you want 24 hours?
yes, I do, Your Honor.
All right, sorry, but I think legally that it isn't probable cause. But anyway, so we'll give the state 24 hours on count one. ROR, do you want 24 hours on count two too?
No,
Okay. All right, well, ROR on count two,
Your Honor, by virtue of that, we would argue there's no probable cause for the drug paraphernalia as well.
there's other stuff
Understood.
for paraphernalia, so we'll find probable cause as it relates to the drug paraphernalia. We'll set bond on that count for the time being at $1,000, but we'll reset for tomorrow. We'll give the state 24 hours for probable cause.
She has a second case, Your Honor?
Okay, so count one.
it does have fentanyl.
What's that?
The second case has fentanyl in it.
No, just the aluminum cans, the syringes.
No,
There's a
Your Honor.
second-
The
a second
second
case
case
she's
is
in on.
23 CF 3894.
Oh, sorry, 23 CF 3894.
Yeah.
Let me see, yeah. Well, that was a warrant, right?
Yes, Your Honor.
All right. All right, so that came in pursuant to a warrant. We'll stay the bonds on count one, possession of fentanyl, $1,000. Count two at $150.
So, that's the one. See?
And a no return to the scene.
I would also ask that she have no contact with the co-defendant, Your Honor.
No problem. No contact with Carlos Torres Cardona. And also, as a condition of the bond on the case where there's a warrant, 3894AO, is that she not possess or consume drugs or controlled substances without a valid prescription. Yeah.
What's the bond for that count? Stay at
Yeah, we'll stay it for now, but it's gonna be reset to, she can't post a bond on it until if we reset it tomorrow, there's gonna be a hold, right? I just wanna reset it, then we'll just take no action on, well, hold on. Yeah, we'll stay them. So on counts one and two, and reset it to tomorrow for probable cause. Okay, two's ROR.
Right.
Yeah.
Your
Count
Honor,
one,
I
we'll stay.
apologize. I do apologize, Your Honor. Since I do have to get probable cause for one, can I also get the 24 hours to get it for two? I do apologize. I said no.
No, that's fine, that's fair.
Thank you, Your Honor.
Yeah.
And I apologize with all the back and forth. I just want to make sure I have the bond amounts correct.
No, I do too. So there's,
Right, okay. Okay, so. count
you
one-
started all this.
Count one,
Yeah.
bond stayed at 1,000. Count two R, count three, you raised to 1,000.
Right,
And you, give the state 24 hours of PC for count one and two.
yeah.
Okay.
Does that sound right? 1,000 on count one.
You raised one?
Oh, yes, if you're leaving it as,
We're staying it as it is right now. We're staying count one. We raised count three to 1,000.
yes.
ROR,
Count two.
or no, we're not RORing on count two anymore.
because you're
Because
giving
we're giving her
24
24 hours.
Okay,
Yeah,
so we're gonna stay at 150.
right.
Okay.
We'll stay count two at 150 and give you 24 hours on count two also.
And we raised count three, okay.
Yep. That's all right. I'm gonna take a minute and breathe so we can think about it.
And then the warrant bonds are
The
not.
warrants, we stayed them, and the conditions, we stayed the conditions on the warrant.
Let's see.
That you'll have to talk to your attorney about in more detail. I don't have too much information about it. Okay? So you'll have to actually.
And the PD's appointed in both cases too, if I hadn't said that. All right. We set her aside for a minute.
Oh, we say her side, yeah, that's right. You didn't say bye, Felicia. I'm sorry.
All right, ma'am.
So you're coming back tomorrow to finish those probable cause arguments, and we'll see where bond is set on those ones, okay? So one, I put ROR, but that's not actually what's happening just yet. So your bonds will be readjusted tomorrow, okay?
Nashua Gonzalez bonded.
But we'll
All right.
see you again tomorrow. And if you can bond that, of course. But we're gonna see what happens. Good luck with everything.
Okay, sir, your name?
David Gross.
All right, Mr. Gross, you're here on a one-count possession of cocaine in 2023 CF 4008 AO. Reviewed the arrest affidavit, do determine there is probable cause. I'll appoint the Office of the Public Defender to represent you. He's got no history.
Say that again.
No, Your Honor, no history.
Any objection to ROR sake? I just see he has no history unless I'm,
No objection.
all right. So you're gonna, we're gonna ROR you as a the release you on, you're going to be released without having to post a bond, okay? I've appointed the Office of the Public Defender to represent you. The only condition of your release is that you stay in contact with your attorney, because if you do get a court date and you miss it, you're not gonna wanna do that. And the best way to not miss court is to stay in contact with your attorney, okay? All right, good luck to you, sir.
In contact with their office, okay?
All right, sir, your name?
Charles Hobart.
All right, Mr. Holbert, you're here, one count of possession of a controlled substance. Reviewed the arrest affidavit, do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you.
And,
Yep.
Your Honor, we would ask, it looks like the bond was set at 5,000, I believe, per the bond schedule.
Yeah, I thought that was high too. What is the bond schedule amount?
I would need to confirm with the state, but I was under the impression it was it 1,000 for this one?
Usually 1,000.
Yeah, I thought it was too. Holbert?
Yes, sir.
Yeah, they were asking your name. All right. All right. Based on the prior failure to appear is pretty recent last year, I'm going to set bond at $1,500.
1,500. Okay, so that's a little less than the 5,000.
No further conditions, okay?
Yes, sir.
All right, good luck, sir.
Thank you.
Here,
Yep.
take this with you, stay in touch with us, okay? Usually, you have to talk to a bondsman, it depends with them, okay?
All right, sir, your name?
Michael Hunt.
All right, Mr. Hunt, this is 2023 CF 3997 AO. It's one count of aggravated assault with a deadly weapon. I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit to determine there's probable cause. Set bond on this case at $2,500. Order that you have no contact with any of the alleged victims. You do not return to the scene where this was alleged to have occurred, and that you possess no weapons, firearms, or ammunition, okay? All right, good luck, sir. All right.
Not right now, but your case will get assigned to an attorney at the public defender's office in the next call, okay?
All right, Ms. Ford, your name, full name?
Felicia Fordyce.
All right, Ms., it's Ford or Ford is,
Fordyce.
so Fordice, one word?
DYCE.
DYCE?
Yes.
All right. 2021 CF 14812AO, it's a warrant for a failure to appear The bond on the warrant set at none. We're gonna stay the bond at none, and I'll appoint the Office of the Public Defender to represent you, okay?
Okay, I didn't have a warrant. I just left from a warrant last week. That's
Well-
like 3 weeks ago.
This is a different one. It's a failure to appear.
Different one? How's a different one?
It's all right. You have an attorney, you have appointed, Office of the Public Defender appointed to represent you. Any questions, you just ask them.
Your attorney over downtown, okay? So she knows you're here. Just talk to her in more detail about what's going on, okay? Just
Okay.
get you back into court.
Good luck. Mm-hmm. Yeah. All right, let's,
And I did have a probable cause argument for the second possession on that one.
state any objection to the, I kind of noted, well, there was two, one was in the bag and one was near him, right?
I understand the argument on that side, Your Honor. However, we have situations and cases like that that come in all the time and they're charged as one count. So we argue that the same thing, lack of probable cause for 2 counts.
All right, this is 2023 CF 4019AO state. So essentially, there was a bag next to him,
No, I see, Your Honor. One was white, one was brown.
right?
But they both tested positive for fentanyl.
Yeah, I'm gonna find probable cause, I mean, whether they file on both, whether different labs come, you know, that was presumptive positives. So I'm gonna find probable causes to each count. I'll appoint the Office of the Public Defender to represent him if I haven't already. It was stay the bond on count 1 at 1,000, count 2, 100. He's also out on bond. Have any of those been filed on? 2022 CF 3790.
It has been, Your Honor, but he's in pretrial diversion, and with regard to 23 CF 1719, he was arrested in February and formal charges have not been filed.
All right, we'll take no action on the 2 cases he is out on bond on, okay? All right, Mr. Lindo? All right, sir, your full name?
Paul Lindo.
All right, Paul Lindo, this is 2022 CF 15015AO. It's violation of condition of your pretrial release. Essentially, you failed to report, so we'll appoint the Office of the Public Defender to represent you in this case. The bond was set, and the warrant was set at $1,000. We're gonna stay the bond at $1,000, okay? All right,
Do I have a court date?
nope, not yet.
To stay in touch with your attorney at the public defender's office, okay? If you
All right.
bond out, okay?
Good luck, sir.
Yes, sir.
All right, sir, your name?
Newman Torres. Newman
All right.
Terraza Torres.
2023 CF 4022AO. It's 1 count of possession of cocaine, 1 count of possession of MDMA. I don't have an out on bond form, but he was out on bond in 20.
He is out on bond, yeah, in 2019 CF 005380 AO.
All right. Well, I'll point that in 4022AO, 2023 CF 4022AO, I've reviewed the arrest affidavit, do determine there's probable causes to count 1 and count 2. I'll stay the bond on count 1 at $1,000, set the bond on count 2 at $100. You're out on bond in 2019 CF 5380AO. I'm assuming charges have been filed, and that was trafficking in heroin, possession of firearm by convicted felon, possession of cocaine, possession of drug paraphernalia. When's his next court date in that case?
April 26th, Your Honor, that's pretrial.
All right, we're gonna revoke the bond in that case, set bond at none, but you do have a court date coming up soon, all right? And if the public defender hasn't been appointed, I'll appoint them in that case.
Take this with you. When you are out on bail offense, you're no longer entitled to bond on that out. If it's not filed, they won't have a
All right, sir, your name?
Tim McCall.
All right, Mr. Call.
And Your Honor, I do have a probable cause argument for this one as well.
Is it as to the two prior?
Yes, Your Honor.
All right, state any objection.
Any objection? Oh,
There's probable cause for the petty theft. The two priors, they don't say he ran them through teletype or anything like that. They just say he has two prior convictions. And
I'm looking at his history, Your Honor. Just last month, he was convicted of grand theft, so I don't think it should be that hard for us to be able to get that information.
Sure.
Can I have the 24 hours, please, Your Honor?
Yeah, we'll give you 24 hours as it relates to the two or more prior convictions, but there is probable cause to the petty theft. So we'll set bond on count 2. Or we'll stay the bond on count 1 at 1,000, stay the bond on count 2 at 100. Order that you do not return to the Mall of Millennia. If I haven't already, I'll appoint the Office of the Public Defender to represent you. He was out on ROR on 2 cases? Or out on ROR in 2023?
No,
No?
no, he doesn't have any first appearance detainers, Your Honor.
All right. Oh, we skipped somebody. I did. You guys did. All right. That's gonna be that for that one then, okay? All right, good luck. No return to Mall of Millennia, and we're staying the bonds on count 1 and count 2, and giving the state 24 hours for PC on count 1. All right, sir, your name?
Desan McGriff.
All right, Mr. McGriff, you're here for failure to appear in case 2021 CF 641AO. The warrant issued based on your failure to appear set the bonds on count 1 and 2 at none. We're going to stay the bonds at none. I'm going to appoint the Office of the Public Defender to represent you, okay? All right, good luck, sir.
And get in front of the judge who actually has your case if you want to resolve it at the bond act, okay? Good luck.
Page? I also have Mitchell. All right. Mitchell, he bonded. That's, yeah, lot going on. So Page refused? Yes, sir. All right, well, 2022 CF 4100BO as a warrant for failure to appear. We'll appoint the Office of the Public Defender and we'll stay the bond at none.
He has another case, Your Honor.
Page?
23 MM002155AO.
Oh, yeah, there it is. All right, 2023 MM2155AO. It's one count of giving false information, one count of resisting an officer without violence. Only question I had on this is the giving false information also the resisting, or was there other resisting?
Not that I saw, Your Honor.
All right. But giving false info is PC for resisting? Is it? I don't know.
I've seen it done both ways, Your Honor. If you found no PC, I would not argue.
Yeah, okay. All right, find probable cause for the giving false information. We'll stay the bond at $250. I'll find no PC as to count 2, we'll ROR as to count 2. All right, sir, your name?
Luis Sandoz.
All right, Mr. Sandos, you're here. Case 2023 CF 4023AO. I'll appoint the Office of the Public Defender to represent you. The only question the court have is 2 counts of aggravated battery with a motor vehicle.
No, Your Honor. One is a battery, the other is an assault.
Oh, I see. Sorry. That's what you get for trying to read fast. All right, so I find probable cause as to count 1 and count 2. We'll stay the bonds. We'll stay the bond on count one at $5,000. Order that you have no contact with the alleged victim. We'll set bond on count two at $500. Also, is, yeah, the same conditions, obviously. No contact with the alleged victim. Any other conditions the state's requesting?
No, Your Honor, but he
Needs
does.
to have a DUI?
Yes.
Yeah. All right, there's also 2023 CT 2190AO, one count of driving under the influence. Reviewed the arrest affidavit, do determine the probable cause. I'll appoint the Office of the Public Defender to represent you, and we'll stay the bond in that case at $500, okay?
To get the facts they're claiming against you, okay? These are allegations against you. Bond. If you bond out, contact the public defender's office, okay? 5,500. Depends with the bondsman, what arrangement you have with them, okay? Bond out, you'll have to contact a bondsman or have your family assist you on that, okay? This is your attorney's office, the defender's office. Call our office to figure out who your attorney is. You can stay in touch with them and they can help you out, okay?
Thank you.
Mm-hmm.
All right, sir, your name?
Robert Sarabia.
All right, Mr. Sarabia, this is 2023 CF 4040AO. It's 6 counts, 1 count of bringing Schedule 2 narcotic into the state, 1 count bringing Schedule 1 narcotic into the state. What is count 3?
And Your Honor, there is one PC argument for this one.
On which count?
Let me get the official terminology. The mushrooms, so to speak, I don't believe they were tested. And that would be,
Counts 1 and 3?
I believe so. I'll probably pronounce the proper terminology wrong.
Hallucinogen?
Hallucinogen I can, yeah, it's the philopin.
All right, where are you getting that word from, the statute?
I believe it was in the police report, Your Honor.
It's page 404 at the top, Your Honor. That's
Oh,
at least where I've seen it. Psilocybin, I think.
Yeah,
You said
psilocybin.
it way better than me.
Yeah, I see it. All right, what's the argument's just that they didn't test it?
Yes, Your Honor, the argument would be that it wasn't tested, and for that reason, there's no probable cause.
State? Did they have to test it? I know they don't have to marijuana.
So we're talking.
Your Honor, it does not appear that it was tested. If you believe that is necessary for probable cause, I would ask for the 24 hours. Chances are it was tested, it's just not listed in here. Or not.
All right. Given the nature of that specific,
It does say that it was field tested and had a field weight, but it doesn't say what it
right.
was.
I've seen that before, and I think I've found no probable cause when they've, even with like cocaine and stuff like this, suspect it's cocaine, then they test it, and they just say presumptive positive and don't say for what. That can be an issue. So, as it relates to counts, let's do this first. Do find there's probable causes to counts 2, 4, 5, and 6. Stay the bonds on counts 2.
And Your Honor, just for my record, what was that bond?
10,000.
Thank you.
Stay the bond on count 3, or count 4, excuse me. That's 30,000.
Thank you.
We'll stay the bond on count 5 at 2,000, and count 6 will set the bond at 250. In the meantime, we're also going to stay the bonds on counts 1 and 3, give the state 24 hours to establish the probable cause.
Your Honor, can I also ask that the defendant abide by Florida statute 903.046, it's sub 2, sub F, and that is with regard to the source of bond.
And defense would be objecting to that, Your Honor.
Again, Florida statute.
Right.
And I do have some case law against it.
Right. What's the objection? I know Nebbia holds used to, we weren't allowed to do that, but then they changed the statute, right?
Yes, Your Honor, it's just done by affidavit.
Right.
So it does not require a hearing.
So what's the objection, defense?
Your Honor, per Sparrow v. State, it says that the defendant cannot be held until the source of income can be determined. While I apologize, Your Honor, I have a memo I'm just going through.
That's all right.
Can you give the cite for that, please?
Yes, so Sparrow versus State, 240, Southern 3rd, 841, 5th DCA, 2018. So based on my information, what's been cited by the state, the statute does allow the court to consider the source of funds when setting a bond. Not that once the bond is set, that they have to provide proof of source of funds. And that is further discussed in Okay, so I see what's going on. So there was a conflict at one point between the DCAs, Your Honor, but in I believe it was Fleury v. State, the Supreme Court Okay.
Yeah, it looks like Sparrow was a Nebbia hold. Nebbia required a hearing. So and then the statute's 903.046.
And that's the statute that,
So it just says the source of funds used to post bail.
hold on, I'm trying to figure this out.
When determining whether to release the defendant on bail or other conditions and what bail the court shall consider.
Your Honor, I believe that's the basis of the argument, is that it allows the court to consider it. It doesn't mean that there should actually be a Nebbia hold until the source of funds are proven.
I apologize, did you give the cite for Fleury v. State, or did you? No. Okay.
Right. So what Sparrow says, they agree with Judge Warner's concurring opinion in Perino to the extent that the court inquires at first appearance as to what source of funds are available to post bail. It is for the purpose of ascertaining whether the bail set is sufficient to secure the defendant's appearance, not to deny him pretrial release. So, and as I read the statute, the plain language of the statute, it says, I guess we've kind of abrogated from Nebbia holds in the sense that the court can consider And I think that's what happens, you know, when someone gets pulled over going down the highway and they've got $250,000 and bales of marijuana hidden in the vehicle, the court can consider the source of funds when determining the appropriate amount of bail, and then in setting a reasonable bond to ensure his appearance in court. I don't see any place where that before he can post bond, there's any requirement that he show the bond, the funds are derived from non-criminal or illicit means. All right. So the state's position is noted. I'm going to stay the bonds that they are. They're pretty high bonds. So, I mean, I've considered the factors that I'm required to consider under 903.0462F in staying the bonds and only doing a subsidiary bond on count 6. So, and then in the meantime, we'll give the state 24 hours for probable cause on counts 1 and 3. All right.
And Your Honor, I apologize. I just want to make sure I understood the ruling by the court, not requiring source of funds.
I don't see, yeah.
Okay.
What I'm doing is considering conduct alleged in the affidavit and staying all the bonds as they are. Count 1, 10,000, count 2, 10,000, count 3, 30,000, count 4, 30,000. Those are significant bonds. I think that's what the statute's saying, is that we consider that. We're not doing, and I am considering that and not setting subsidiary bonds.
Thank you, Your Honor.
You're right.
Just wanted to confirm. Did you have any other
So
questions?
we gonna do the statute or no?
No.
No, we're not, okay, so
Yep.
we're just gonna leave, like you said, give the state.
24 hours on counts 1 and 3 and staying them PC as to all the other counts. It's been found, and then we're staying, except for count 6 is 250. Got it. All right. All right. All right, good luck, sir.
Should be able to bond out. I missed one of these. There's one other bond in there, but you have the number, okay? Should, as long as nothing else is holding you and nothing else is going on.
All right, sir, your name?
Richard Sears.
All right, Mr. Sears, you're here in 23 CF 3717 AO. It's pursuant to a warrant, one count of fleeing and eluding. You're also, so we'll do that case first. 3717 AO. I'll appoint the Office of the Public Defender to represent you. Probable cause determination has been previously made by the judge who signed the warrant. Count 1 will set bond. At $3,500. You're also here in 23 CF 4005 AO. One count possession of cocaine, one count possession of Plazaram, and one count of possession of drug paraphernalia. I'll appoint the Office of the Public Defender to represent you in that case as well. I've reviewed the arrest affidavit. Do determine there's probable causes to each count. I'll stay the bond on count 1 at $1,000, count 2, set bond at 100, count 3, set bond at 100. All right? If I didn't already, I'll appoint the Office of Public Defender to represent you in that case as well. So good luck, sir. Yep. All right, sir, your name?
Terrion Shepherd.
All right, Mr. Shepherd. You're here on warrant for a failure to appear in case 2021 CF 6069 AO. The bond in the warrant. At none, we're going to stay the bonds at none. I'll appoint the Office of the Public Defender to represent you, okay?
What'd you say?
Yeah, good luck.
Is none, you'll have to talk to. Okay? Good luck.
Could I say one thing, sir?
All right, you failed to appear on 3/2/2023. You can say the warrant's been signed by the judge in front of whom you failed to appear, so that's all we're doing today. You have the right to remain silent. Anything you say can and will be used against you. I've appointed the Office of the Public Defender to represent you. Anything you want to say, you might want to run it by your attorney first. So, all right, good luck, sir. All right. I didn't even, Stevenson. I had his face sheet. Huh? Who was that?
That guy that just left.
That was Latarian Shepherd.
Oh, okay. He said who?
I got a face sheet. I don't have an affidavit. Oh, I do. Yeah, I do. What happened to Jerome Sims?
Do you have
All
a
right.
booking number for Sims?
Yeah, 23007-964. There's Stevenson.
They bonded.
All right, Sims bonded. All right. Ms. Thompson? All right. 2023 CF 3737AO. Ma'am, your name? Your name?
Chantel Thompson.
All right, Ms. Thompson, you're here pursuant to a warrant for your arrest. 3 counts: conspiracy to sell, deliver controlled substance. Count 2, to sell, deliver cocaine. Conspiracy to sell or deliver cocaine. Count 3, unlawful use of two-way communication device. Bond on count 1 is set at 1,000. Count 2, 150. Count 3 at 150. We're going to stay the bonds and order that you have no contact with any co-defendant. Okay? All right. Good luck, ma'am. If I didn't appoint the PD, I'll appoint him. All right, sir, your name?
Carlos Torres Cardona, sir.
And Your Honor, we do have a probable cause argument for this one. It's the co-defendant on that prior case.
So I appoint the Office of Public Defender to represent you. Reviewed the arrest affidavit. We've had the same arguments in the case of Miss Fox. So, under the doctrine of Goose v. Gander, it's not a real case anyway. So, we're gonna give the state 24 hours on counts 1 and 2 to establish probable cause. We're gonna stay the bonds on those counts. We're gonna set bond on count 3 at $1,000. He was also out on bond in 2022 CF 13941AO.
Pretrial is set for May 3rd, Your Honor.
All right. Yeah, and that, as a condition of your bond in 2023 CF 41010AO, I'm also going to order that you have no contact with Ms. Fox, okay? And you're also out on bond. The case you're out on bond on, I'm going to revoke the bond and set bond on none. You do have a court date coming up next month. I'll appoint the Office of the Public Defender to represent you in that case if they haven't been appointed already, all right? Yeah, for the new case, but the case he was out on bond on, we're revoking and setting at none.
Your Honor, is there any way we can not revoke his bond?
I'm gonna, there is a way, but we're not gonna do that right now. He's gonna have to go see the judge in Division 14 in order to get a bond, all right?
Understood.
All right. All right, good luck, sir.
It's ordered, so remember that.
And just, the no contact order, just keep in mind, jail phone calls are recorded, all right? All right, sir, your name?
Joshua Jameer Torres.
All right, Mr. Torres, this is 2021 CF 8082AO. It's one count, or it's a failure to appear for a trial management conference on June 1st, 2022. Bond in that warrant was set at $8,000. We're going to stay the bond at $8,000. I'll appoint the Office of the Public Defender to
Your
represent.
Honor, I may have, okay, I apologize. Sure, Torres.
All right.
Okay, apologize, I'm back where we're at. I had
Okay.
a moment.
Josh Torres, so, all right. Okay, so you got a bond in the warrants, $8,000. We're going to stay the bond at at what it's set at. I'm gonna appoint the office of the public defender to represent you if they haven't been previously appointed, okay?
Sir.
All right, good luck, sir.
Good luck with everything. Stay in touch with your attorney, okay?
All right. All right, sir, your name?
My name's Kirk Triplett.
All right, Mr. Triplett, you're here for failure to appear at a pretrial conference on January 24th, 2023, in case 2021 CF 14617AO. Bond as to each count is set at none. We're going to stay the bonds at none. I'll appoint the office of the public defender to represent you if they haven't been previously appointed, all right?
May I say something, please, sir?
You can say whatever you want and understand that you have an attorney appointed to represent you, and everything you say is being recorded and may be used against you, so.
Yes, sir.
Yeah.
I understand, sir. I was incarcerated in the Leon County Jail during this whole time. I just got out of jail yesterday.
All right,
And so a failure to appear was issued on me while I was in jail.
right. So
What I'm requesting for is R&R today because I should
it's not
not,
gonna happen today. It's not gonna happen today. You're gonna have to go see the judge that signed the warrant. If we just took everybody's word for whatever, then everyone would just get out of jail.
no,
So
but you can check the computer. I've been locked up.
we're not doing that today. I'm not saying you're not gonna, right now you have no bond, you can go see the judge and they can make that determination, but the judge that signed the warrant, so.
What he's telling you is it has to go in another judge. The judge that actually has this case. So you think today, talk to your attorney and they'll help you out to get you in front of that judge. You can't have fun with it, okay?
All right, good luck, sir. All right, White,
Yes, sir.
happen to, did I turn White over? All right, sir, your full name?
Jason Raphael White.
All right, Mr. White, you're here in 2023 CF 3381AO. It's pursuant to a warrant, one count of burglary of a structure, one count grand theft third degree to alleged to have occurred on or about January 26, 2023. I'll appoint the office of the public defender to represent you in that case. The bonds was set at $7,500 on count one, $2,500 on count two. No contact with any alleged victim and no return to the scene. You're out on bond on a burglary in case 2022 CF 9791AO. Got a court date in that case on April 5th. PD's been previously appointed. We're going to revoke bond in that case, set bond at none, okay? All right, good luck to you, sir. All right, 2023 CF 3992AO. One count, possession of cocaine, one count, resisting an officer without violence. Viewed the arrest affidavit. Do determine there is probable cause. I'll appoint the office of the public defender to represent Mr. Williams. Stay the bonds in counts 1 and 2. Actually, we'll stay the bond on count 1, sorry. Set bond on count 2 at $100. Appoint the office of the public defender to represent him in that case. He was out on bond on 22 CF 13478AO for possession of cocaine. We're gonna revoke bond in that case, set bond at none. He's got a court date April 5th. PD's been previously appointed. All right. Thank you, everyone. We'll be in recess until tomorrow. All right. All right, sir, your name? All right, Mr. Pickard, this is 2023 MO431AO. One count of resisting an officer without violence. Yesterday, we appointed the Office of the Public Defender to represent you and, or no, I don't think we did. Yesterday, we just found a probable cause determination, but we reset you for today because I think the state had an offer for you. So what are we doing with this one?
The offer from the state is an adjudication of guilt, credit, time served, and Mr. Pickard would like to accept the state's offer and enter a plea of no contest. Your Honor.
All right, Mr. Pickard, form you're signing, there's a plea form. You ever seen that form before?
Yes, sir.
All right, you understand that by resolving your case here today, you're waiving the rights that are listed on that form?
Yes, sir.
All right, why don't you go ahead and sign the bottom of it? We'll go over it with you once it gets up here. All right. You under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? All right, anyone threaten you or coerce you to enter this plea?
Yes, sir.
All right. So you signed the bottom of the plea form. You understand that by resolving your case here today, you're waiving the rights that are listed at the top of the plea form?
Yes, sir.
All right. You understand that if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes, sir.
And do you understand that if you're on probation for a separate offense, a plea to this offense might be used to violate that probation? All right. Well, accept the no contest plea. We'll adjudicate you guilty. Was he 3 days?
Yeah, 3 days.
All right. Since you're 3 days in the Orange County Jail with credit for 3 days' time served, also have to impose mandatory court costs. We'll give you 1 year from the date of your release to take care of the court costs, or be on a payment plan making regular payments. Otherwise, the clerk's going to suspend your driver's license, okay? All right, you have 30 days to appeal the judgment and sentence. Good luck.
Any action on the out on?
Oh, and we'll take no action on the case you were out on bond on, 2021 CF 13893AO. Just understand that when you're out on bond, you get picked up for new stuff, you're not entitled to a bond anymore, okay? All right, so good luck and just be aware of that. All right.
What's the 29th?
I have it here. It looks like you have one. Yeah, it's this date, so don't miss it. They say they require you there. I'm just giving them this court date. Hold on. Okay. That's the next one.
All right, sir, your name?
Justin Almonte.
All right, Mr. Almonte, this is 2023 CF 4025AO. Ma'am, your name?
Veronica Wolf?
All right. All right, ma'am. Raise your right hand to be sworn, please. You swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. All right, just so we're all aware, everyone that's out there too, aware of what's happening here today. In these domestic violence situations, you're held no bond until you can see the judge, okay? And what happens when you see the judge, we determine the appropriate bond. You are entitled to a bond and then conditions of release. Conditions of release can include things like no contact. I can order that he have no contact with you, that you maintain separate residences, that he can't go back to the house, that you consume no alcohol, drugs, you know, if that appears to be a significant factor. Or can order, we can order that you are allowed to have contact with each other, that you are allowed to live together, but that's going to be up to the court. In order to determine the appropriate conditions of release, we're going to have some questions for you, okay?
Okay, but,
All right. That's all right, but
I would
so,
like to allow,
yeah, we're gonna get to that.
okay.
So, you two living together? Are you two living together?
Right now, yeah.
Okay, do you wanna be able to live together?
Yes.
All right, so are you afraid of him? No? Anything like this ever happened before?
No, because nothing really happened.
Okay. So you wanna have contact with him?
Yes.
All right. State, do you have any questions?
No, Your Honor.
All right. Yeah, based on the facts, I've reviewed the arrest affidavit. I do determine there's probable cause. Based on the facts alleged in the affidavit, I will allow you to have, and the testimony received here today, the conditions of your bond are going to be as follows. That you have, well, let's set the bonds first. On count one, set bond at $500. Count two, 100. Count three, 100. With the following conditions, that you have no hostile contact with her, okay? No hostile contact means you two can have contact. Hostile contact is anything that could be construed as hostility, raising your voice, arguing, shouting, anything like that. And just so you know, the court's order, it's only on you. So if they, you know, start arguing, she starts raising her voice, she doesn't have a court order on her, it's only on you, okay? So if anyone sees that, or she calls the police and says that you're yelling at her, that's gonna be a violation of a condition of your release. Your warrant will be issued and you could be arrested and held no bond, okay? All right. I'm also gonna order that you possess no weapons, firearms, or ammunition. Anything further, State?
No, Your Honor.
All right, good luck to you. I'll appoint the Office of the Public Defender to represent you in this case if I haven't already. Other than that, good luck to you, sir.
All right, thank you.
All right. All right, sir, your name?
Gavrosh Cadet.
All right, Mr. Cadet. You're here pursuant to an arrest warrant, so probable cause determination's been previously made by the judge who signed the warrant. There's 3 counts in the warrant. Count 1 is kidnapping. Count 2, aggravated battery, great bodily harm, which was domestic in nature. Count 3 is robbery by sudden snatching. I'll appoint the Office of the Public Defender to represent you in that case. Will stay the bond on count 1 at $20,000. Set bond on count 2 at $2,500. We'll stay the bond on count 3 at $5,000 with the condition that you have no contact with the alleged victim, do not return to the scene where this was alleged to have occurred, and that you possess no weapons, firearms, or ammunition. You're also out on bond as of 4 days before you bonded out on March 6th in 2023 MM104AO and 2023 CF7631AO. 4 days later were the allegations that led to the warrant being issued. So we're going to revoke the bond in both those cases, set bond at none. Okay? I'll appoint the Office of the Public Defender to represent you in those cases if they haven't been appointed already. All right, so you have attorneys. Good luck, sir.
Because it was, no return, no weapon.
Yeah. All right, your name, sir?
Vladimir Joseph.
All right, Mr. Joseph. All right, I'll appoint the Office of the Public Defender to represent you in this case. I've reviewed the arrest affidavit. Do determine there's probable causes to counts 1 and count 2. State have a position as to an appropriate bond in this case?
Your Honor, as he has no history and no injuries were noticed on the children, maybe $1,000?
All right. Sir, I'm just going to tell you, you have the right to remain silent. Everything you say can and will be used against you. I advise you to exercise that right because I'm going to say some stuff. I don't want you to say anything. You have an attorney appointed to represent you, so today is not the day to kind of tell your side of the story. It's just, I'm just going by what's written on the paper and I'm going to set a bond in appropriate conditions, okay? So I'm just advising you. If anything you want to say to the court, you probably want to run it through your attorney, okay?
You had one question, Your Honor.
Yep. Hold on, just say it to her. Anything you say can be used against you, anything she says can't be, so.
Okay, thank you, Your Honor.
All right. Here's the problem I have. I understand he's got no prior history. The problem I have is that when the cops show up, he told the cops that this is a lie being told by his wife, when the 6-year-old also told the police that her dad pushed her. So not only is he calling his wife a liar, he's calling his 6-year-old daughter a liar. That doesn't sit right with me. I'm gonna set bond on count 1 at $5,000, count 2 at $2,500, with the following conditions. Since they're not here, and you have an attorney appointed to represent you, so this can be modified, but it's not gonna be, you're gonna have to have no contact. You have to have no contact with any of the alleged victims until further order of the court. I'm also gonna order that you have no contact with Cynthia as well until further order of the court. If you need to go back to the residence, you may go back one time to get any personal belongings with the presence of law enforcement. Other than that, you must maintain separate residences from Cynthia and the 2 minor children. I'm also going to order that you possess no weapons, firearms, or ammunition.
You go out of state? Okay.
Yep.
Your Honor, did you make a condition to comply with any plans set in place by DCF?
Yes, I meant, I didn't say that, but yes, they also is a condition that if, since DCF was called, you have to comply. I don't know if they're gonna impose any conditions, but if DCF imposes any conditions as a condition of your bond, you're gonna have to comply with the DCF conditions if they impose any, okay?
And also, Your Honor, he is a truck driver and he travels out of the state 4 weeks at a time. Could he be allowed to, for his job, travel?
I got no problem with you traveling for work. All right? All right, good luck, sir. All right, sir, your name?
Say your name. No, you're fine.
Abdel Rahman Kalilatia.
All right, sir, you're here pursuant to a warrant that was issued for your arrest with 3 counts. Count 1, aggravated stalking after an injunction. Count 2, burglary of a conveyance. Count 3, grand theft, 3rd degree. So probable cause determination has been made as to each count.
Your Honor,
Yeah.
before you make a bond decision on count 1, if you would review his history, his last conviction was last year, and that was for violating a domestic violence pretrial release. He, against this same victim, he has numerous acts of.
He's also out on bond on 1, so.
And I believe that was entered in error, Your Honor, that out on bond. He didn't actually get arrested or bond out until after this current warrant occurred.
But again, Your Honor, these
Okay,
are
all right.
happening close in time with the same victim.
So he bonded on 3/10, and this was March 7th. Okay, I see.
Correct, Your Honor.
I see. All right. appoint the Office of the Public Defender to represent you in this case. Yeah, based on your history, based on the history with the same victim, I'm gonna set bond in this case at $50,000 with the following conditions. Count one is $50,000. Count two will stay the bond at $5,000. Count three will stay the bond at $250,000. That you have absolutely no contact with the alleged victim. I'm saying that again. I know other judges have told you that and it hadn't meant anything, but if you violate these conditions, you'll be picked up and held no bond, okay? You understand that? All right. So absolutely no contact with the alleged victim. No text messages, emails, communications through third parties. And those conditions apply starting right now. Just so you know, all the jail phone calls are, all the jail phones are recorded. So that applies even before you bond out, okay? So no contact whatsoever with the alleged victim, no weapons, firearms, or ammunition, no return to the scene where any of these alleged offenses are alleged to have occurred. And that's gonna be that, all right? We're just gonna take no action because this happened after or before he bonded.
Your Honor, my client can't afford a $50,000 bond. He only works at a restaurant. He doesn't have much criminal history. I only see 2 misdemeanors that he's been convicted of. I'm looking at the right thing. A pretrial release violation.
For violating a domestic violence injunction. Here's the thing. If you want to modify the bond, you're going to do that with a motion with some proper testimony on what you can afford and all that. But right now, the bond's being set for the purpose of, safety to the community. Because we've issued numerous injunctions and he doesn't get it. Keeps violating them over and over and over. Stop. So until it's modified by a further order of the court, the bond is gonna be what it's gonna be. And sooner or later, you're gonna have to learn you gotta leave this person alone.
Your Honor, what was count 3? I'm sorry, I missed it because we were
The
talking.
bond on count 3?
Yes, Your Honor.
We stayed it. I think it was 250.
Thank
Yeah.
you.
All right. Good luck, sir.
Reduce it.
Okay.
If you can afford that, no.
All right, sir, your name?
Bernard Mahone?
Mahone? All right, 2023 CF 3927AO. You were arrested pursuant to a capias. I guess an information's been filed, correct, State?
One moment, Your Honor.
Saw people moving around out there, but that's all right. All right. My review of this case earlier was just that the state filed charges. There's not necessarily a probable cause. The state's already pursuing charges on this, okay? So that's,
Yes, Your Honor. An amended information was filed 3/27.
all right. So the state filed charges against you, though it's 1 count of battery, domestic violence with 1 prior battery. I'll appoint the Office of the Public Defender to represent you and set bond in this case at $1,000 with the following conditions. Yep, hold on. Just so you know, anything you say can and will be used against you. We're not getting into the facts of what happened or anything like that, so I've appointed an attorney to represent you. You might want to run it through her. All right, so set bond at $1,000. Because the alleged victim's not here, I have to order that you have no contact with the alleged victim. Can you get a copy of the information?
I don't have it printed, Your Honor, because I just have it on my computer. I don't know if you.
I can print the
Okay.
information.
All right.
Yeah, she'll print it for you.
Please do, 'cause I don't even know this.
That's what I'm saying. It's not really clear. I want you to know, because I'm ordering you have no contact with this person. You need to know who it is. All right. So I'm gonna order that you have no contact with the alleged victim, that you possess no weapons, firearms, or ammunition, okay?
Yes, sir.
All right.
He has no condition, do not return to the scene, do not possess and maintain.
He's about to print it, just give her a second.
He does?
Yes, on the case, if you look.
On the capias?
See.
All right, so the judge who signed the warrant, they also, here's the conditions that they impose. No contact directly, and we're gonna stay these conditions. No contact directly with the victim, co-defendant, or any witness. Maintain separate residences. No return to the scene of the offense. Do not possess, consume any alcohol, illegal drugs, or controlled substance without a valid prescription. And do not possess any weapons, firearms, or ammunition.
Even though what is offense.
That's it. Well, that's that information should be,
I am printing it now.
all right. We're gonna try to get you that information, all right?
I'm very lost on this whole.
That's all right.
Whole case, anything, because I never been arrested for it, and I never been in court for it.
That happens sometimes. It happens sometimes, but we're gonna get you have an attorney appointed to represent you. So, any questions you have about the facts of this case, you want to direct those to your attorney. Don't be saying them out in open court, all right? All right, good luck.
Your Honor, it is showing that it's printing. It's just really, really slow. It says it's printing.
Yes, coming.
Hold on.
No, it's printing. Thank you, Madam Clerk.
Does it have the scene, the alleged location?
The one,
Is it?
It has the date and the person, but it does not have
The address.
Address, no, Your Honor.
All right, just read it. Don't say anything out loud. We're not contesting. Those are just that's the state's charging document, so you can't have contact with that person. And if that refreshes any recollection, you can't go back to the alleged, to the scene where the alleged offense occurred, okay? All right. Good luck. Today's not the day to fight it. I understand you may not know, but that's just what it is, all right? Good luck. All right, sir, your name? All right, Mr. Mayor, you're here on 2023 CF 4012AO. Ma'am, your name?
Meridine Sinclair.
Speak up a little bit.
Meridine Sinclair.
All right. Ma'am, raise your right hand and be sworn, please. Do you swear or affirm testimony you're about to give be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. You were out there earlier. You kind of understand what's happening here today, ma'am?
Yes, sir.
All right. So, you two living together? Yes?
Yes, sir.
All right. You want to remain living together?
Yes, sir.
All right, you scared of him?
No, sir.
All right, anything like this ever happened before?
No, sir.
All right. Say, do you have any questions?
No, Your Honor.
All right, well, I reviewed the arrest affidavit. I do determine there's probable cause as to the count of aggravated battery, battery by strangulation. While appointing the Office of the Public Defender to represent you, set bond in this case at $500 with the following conditions. But you have no hostile contact with her, okay? No hostile contact means no raising your voice, arguing, anything like that. If you start raising your voice, have anything that can be construed as hostile contact, if anyone sees that or she picks up the phone and calls police, you'll be in violation of the conditions of release and you'll be picked up and held no bond. You understand that? All right. Also, that you possess no weapons, firearms, or ammunition. I'm also going to order that you possess or consume no alcohol while you're out on bond, okay? It seemed to be a significant factor in what happened here, so we're going to order that you do not possess or consume alcohol. If you violate any of those conditions, like I said, you can be picked up and held no bond, okay? All right. Good luck to you, sir.
And then Mr. Mayor should just be aware, he does have an immigration hold.
All right, you have an immigration hold that may have to be cleared up before you're released, okay? All right, good luck. All right.
What happened to John Self?
Oh, yeah. I got him.
Okay. But you said Shepard refused? Thank you.
Yeah.
For self?
No, I mean, I have him up. Do you need his info?
You don't have self? He's not back, yeah. So so he's not back there, that's fine. Can we get him this afternoon? Yeah, can we do that? You need a MA number? Yes. 220-29-656. Is anyone out there for John Self? Anyone out there for John Self? Okay, we'll just do him this afternoon.
And Shepherd refused.
Shepherd refused?
I will waive the appearance, Your Honor.
All right. He's got 3 cases, 2023 MM 2049AO.
Shepherd.
He refused.
Can you issue warrants for misdemeanors? For misdemeanors, you can issue warrant? I thought, I mean, I don't know anything. I just work here. So- All right, all right.
It's not a lot.
There's a statute out there. I'm gonna read it over lunch. Because now, I don't think you can issue warrants for misdemeanors. Anyway. But we did it. So there's a warrant that was issued, so probable cause determination's been previously made by the judge who signed the warrant. We'll set bond in that case at $500. Order no contact with the alleged victim or the victim's minor children. No weapons, firearms, or ammunition, no return. He's also on a warrant on 2020 CF 9530. That was a failure to appear. The bond in that warrant set at none. We'll stay the bond at none, appoint the Office of the Public Defender to represent him in that case. Also, 2023 CF 3976 AO, possession of a firearm by a convicted felon. Reviewed the arrest affidavit, do determine there's probable cause. Based on his history, I'm gonna set bond on that case at $10,000, no weapons, firearms, or ammunition. All right. All right, sir, your name?
Justin Block.
All right, Mr. Black.
Your Honor, defense would argue, no PC, that this is just a blanket statement.
Yes, all right, I wrote on here 24 hours, so.
Yes, Your Honor. Bearing that in mind, okay, that's fine, Your Honor, as long as you leave the bonds as is, including the no bond on the battery. And the reason that I make that request, Your Honor, is his out on bond is a violation of probation. He bonded out, I believe, on the 27th. And one of the conditions was that he have no hostile contact with this victim. The allegation is that he punched her in the face.
All right,
Your Honor.
hold on. Today's not the day to do it. You have the right to remain silent. Anything you say can and will be used against you. The only thing we're doing today is determining conditions of bond, or whether you're entitled to a bond and the appropriate bond conditions. The state's entitled to an additional 24 hours to establish probable cause because the documentation that was submitted is just a blanket statement, doesn't really contain any facts. But under the law, they're entitled to an additional 24 hours to provide the court with that information. Court's gonna give them the additional 24 hours. In the meantime, the court's gonna take no action on your bonds as they are, so you're gonna be held as the bonds that they came in. No bond on count 1, 500 on count 2, 100 on count 3. And there's also gonna be a hold on you pursuant to your out on bond on 20, 20 CF 3913AO. So we'll see you probably tomorrow, okay? And I'll appoint the Office of the Public Defender to represent you in each case.
See you tomorrow.
Yeah. No, it's 31st. Yeah. 30 days has September.
So we'll see you tomorrow. Yeah, so you'll come back tomorrow and we'll deal with it.
April, June, and November, all the rest have 31, except for February, who's special. Yeah. All right, sir, your name?
Dante Bonino.
All right, Mr. Benino, you are here, 2023 MM151AA. Ma'am, your name?
Lorraine Torres.
Get a little closer to the microphone.
Lorraine Torres.
All right, ma'am. Just raise your right hand to be sworn. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. All right, so you've been sitting out there, you understand what's happening here today? All right. You two living together?
Yes.
All right. You want to continue living together?
No.
Okay. Do you want to have any contact with him?
No.
All right. State any questions?
No, Your Honor.
All right, sir. So here's what we're doing today. Today on domestic violence situations, you're held no bond until you can see the judge, okay? And then once you see the judge, what we're doing here today is just setting a bond and appropriate conditions of release. In order to do that, we take some testimony from the alleged victims who show up. And based on the testimony, we set the appropriate conditions. So what I'm gonna do in your case, I'll appoint the Office of the Public Defender to represent you. I've reviewed the arrest affidavit, do determine there's probable cause. Let's have bond in your case at $250, okay? With the following conditions. Let me ask you, ma'am, this. Where this happened, who's living there?
Me and my daughter.
All right, where does he live?
At the same residence?
All right. But you don't want him to come back there?
No, he does have somewhere else to go.
All right, so here's what we're gonna do. It's a condition of your release. You have no contact with the young lady in the box here, the alleged victim in this case, okay? No contact means no contact. It means no text messages, emails, communication through third parties, TikTok, Facebook, anything like that, okay? So the minor child, is he the father?
Yes.
All right.
And I do want to dismiss the charges.
Do what?
I do want to dismiss the charges.
You want to dismiss them? Well, we're not doing that today, but you can, you can contact the state attorney and his attorney. I've appointed the Office of the Public Defender to represent them, so he has an attorney. But until then, the conditions of bond are gonna be this, okay? They have no contact with her, no contact with her, cannot go back to the residence where this was alleged to have occurred. I'll allow you to go back one time with the presence of law enforcement. The way that works is you call law enforcement first, okay? You set up a mutually agreeable time for you to go back there, get any personal belongings you need out of the house. Other than that, you can't go back to the house until further order of the court. Also order that you possess no weapons, firearms, or ammunition. Is there anything further from state or defense?
Nothing from the state.
Nothing from defense, Your Honor.
All right, good luck, sir.
Thank you, Your Honor.
Yep. All right, ma'am, your name?
Crystal Bostic.
All right, Ms. Bostic, you're here, one count of battery, domestic violence. I reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. Because the alleged victim's not here, I have to impose the following conditions, okay? Well, I'm gonna set bond in your case at $250 with the following conditions. You have no contact with the alleged victim. That's, no contact means no contact. Text messages, emails, Facebook, TikTok, Instagram, anything like that. No communication through third parties, anything that can be construed as contact. Also, that you possess no weapons, firearms, or ammunition. Also order that you two maintain separate residences. If you need to go back to the residence where this occurred to get any personal belongings, you can do so one time with the presence of law enforcement. Other than that, the two of you just must maintain separate residences. If you're living there, then you can live there as long as she's not living there. But if she's living there, you can only go back one time and get personal stuff, and then you gotta stay somewhere else, okay? All right. Anything further? All right, good luck. All right. All right, who's out there for Shivani? Yeah. All right, this is 2023 MM2154AO. I'll go ahead and appoint the Office of the Public Defender to represent Mr., how you say the last name? How you say the last name?
Shavni.
Shavni?
Yes.
Excuse me. All right, ma'am, your name?
Tierra Ellerby.
All right. So, Mr. Shavni wasn't brought up this morning due to some behavior issues, so he's not being transported, but we're gonna still do conditions of, since you're here, we're gonna not waste your time and set some conditions of his release, or of his bond, okay? Cindy, just go ahead to the best of your ability. I know you got precious cargo in there, but just raise your right hand to be sworn, okay? Do you swear affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, your name again?
I'm Tierra Ellerby.
All right, Miss Ellerby. Do you want to, you've been sitting out there, you kind of understand what's happening here today?
Yes, I do.
All right, do you want to have contact with him?
Yes, I do.
All right, you two living together?
Yes.
All right, so you want him to be able to come back home?
Yes, but we were not.
Huh?
We were not at our residence. We were at his brother's house.
Right. Anything like this ever happened? You ever been violent with you before?
No, we haven't been violent.
State, and the alleged battery in this case is like a shoulder bump, right? Is
That's what the officer claimed. They obviously didn't need probable cause, but if they view his body cam, he did not touch me. He gave me my baby and her pacifier.
Yeah.
And he called me a name and walked off.
Right.
And the officer said, "Oh, you shoulder checked her," and went to roughing him up.
Okay.
That is correct, Your Honor.
Right, I just read, I was just making sure
What
that.
you said, I apologize. Your characterization of what happened, yes, that is what is in the report, yes.
Okay. All right, well, just for today's purposes, and I'm not saying, you know, we're not getting to the truth of what
Here's the
actually
baby.
happened.
She's fine.
I understand. I just gotta go by what he wrote down, all right?
Yes, Your Honor.
For today's purposes only.
Okay.
So I do determine there is probable cause by what he wrote in the paper.
That's how he wrote it.
Yeah, I understand. We set bond on count one at $250. Count two at $100 with the following condition that he have no hostile contact with you. It just means no arguing, raising voice, anything that can be construed as hostile contact.
Yes, Your Honor.
And that he possess no weapons, firearms, or ammunition, okay?
Okay.
All right, good luck to you, ma'am.
Thank you.
Uh-huh. Thanks for coming. All right, sir, your name? All right, Mr. Johnson, this is case 2023 MM2151AO. It's one count of domestic violence. I've reviewed the arrest affidavit. I do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you.
This is, I guess I'll argue, no probable cause, Your Honor. It's a unique one.
The scratches?
Well, the scratches are there, however, both parties is stating that nothing occurred. The person who he mentions witnessed is a witness, did not witness the event. He stated it was told to him by the client, however.
Here's the part, I understand what you're saying, because I had to read this 2 or 3 times as
Okay.
well. Yeah, I mean, there's some hearsay layers in here, but hearsay's allowed when establishing probable cause, so the fact that the witness told the officer that the victim told him. That's gonna be sufficient to establish probable cause. And the fact that both are saying nothing happened, the court's gonna know that there's been 4 prior arrests with the same victim with no convictions. So there seems to be a pattern of things happening and then everyone saying nothing happened. So we're gonna set bond in this case at $1,000. Because she's not here, I'm gonna order that you have no contact with the alleged victim. No contact means no contact. No text messages, emails, communication through third parties, lawyers. Well, lawyers are different, but no communication through relaying messages through family members, anything like that. Also, that you maintain separate residences. If you need to go back to the residence one time to get any personal belongings, you may do so with the presence of law enforcement. The way that works is you call law enforcement first, set up a time to go over there, get anything you need out of the house, and then other than that, you gotta maintain a separate residence. Also order that you maintain, or that you possess no weapons, firearms, or ammunition. All right? And if I haven't already, I'll appoint the Office of the Public Defender to represent you, okay? Good luck, sir.
Gladys Matilla is mental health.
All right.
Defense will waive, Your Honor.
Hold on, what are they, hold on. He wants to tell us something.
Oof.
Lights out? I can't hear you. I'm sorry, I just couldn't hear you.
Next client?
Yeah.
Next is Gladys.
Yeah. The next one.
I just wanted to say something about that when she comes out.
Oh, okay.
I was there at the scene at Disney last night.
All right, so they're not bringing her out. But
Because I don't think her husband, Miguel,
Yeah.
is here because I was with her during the part when we arrested her.
Uh-huh.
And he only spoke Spanish, and I think Disney kind of pushed him out, and he wasn't told that he needed to come here today.
Okay.
Their relationship, from what I saw, seemed okay, just for the one incident that happened there at in the statement.
All right. And sir, your name?
I'm Deputy Ayala with the Orange County Sheriff's Office. My EID is 4395.
All right, this is case 2023 MM2159AO. I'll appoint the Office of the Public Defender to represent Ms. Mantilla. I reviewed the arrest affidavit. I do determine there is probable cause. She has no prior history. Based on the information provided by the deputy, is there any objection to ROR with conditions?
Because with due respect, I would have told, when they told me that they sent her, her husband and her cousin away, I was like, nobody spoke Spanish. I was gonna tell them about coming here today. That's what upset me with Disney management.
So what you witnessed, you didn't witness the alleged battery?
No, I did not.
I don't think anyone was able to contact.
He called and left a voicemail for the victim with the court information, so they knew when it was.
And Your Honor, the only reason that I would object to ROR is because also on the face sheet, it does say that he has a prior domestic violence, but it's with a different victim. Or she does, I apologize,
Yeah.
she does.
I mean, we've all spent all day at Animal Kingdom. She slapped him around the head. Wasn't hot yesterday though, so.
Right.
Here's what we're gonna do. We're gonna set bond at $250. Because he's not here, I have to order that they have no contact. I appreciate you coming down here. It sounds like we called him. I'll appoint the Office of the Public Defender to represent her. And if they need to get that modified, they can get that modified. But thank you so much. No weapons, firearms, or ammunition.
Could you have a one-time return, Your Honor?
Yeah, one-time return. to get any personal belongings. All right.
So is that no return or is that separate residence? I apologize.
We'll do separate residence. But if he's not living, the same thing. Separate residences, if she needs to go back to residence one time to get personal belongings, she can do that. Yeah, you can put it.
This number.
I always see him in the parking lot. Yeah. All right. Sir, your name? You can come up. You can come up. Other one.
Wilson Ovens.
All right, Mr. Ovens. This is 2023 MM214AW. It's one count of battery. Reviewed the arrest affidavit. Do determine there's probable cause. I'll appoint the Office of the Public Defender to represent you. You do qualify for what's called pretrial release, which is a non-monetary release, so you'll be released as it relates to this case without having to post a bond, but there's going to be some conditions, okay? All right, so the conditions are because the alleged victim's not here, I have to order that you have no contact with the alleged victim, okay? No contact means no contact, no text messages, emails, Facebook, anything like that, no communication through third parties with the alleged victim. Also order that you maintain separate residences from the alleged victim. If you need to go back to wherever you were living one time, you may do so with the presence of law enforcement to get any personal belongings. Other than that, the two of you got to stay in separate places, okay? Also order that you possess no weapons, firearms, or ammunition. All right, good luck to you, sir. Maintain separate residence. I think it happened somewhere else. PTR. All right, sir, your name?
Victor Velasquez.
All right, Mr. Velasquez, you're here on one count of battery domestic violence. Reviewed the arrest affidavit. Do determine there is probable cause. I'll appoint the Office of the Public Defender to represent you. You also qualify for what's called pretrial release. That's non-monetary release. You'll be able to you'll be released as it relates to this charge without having to post a bond. Because the victim's not here, I have to impose the following conditions. You have no contact with the alleged victim. No contact means no contact. Text messages, emails, Facebook, Instagram, anything like that. No communication through third parties or anything like that. That you possess no weapons, firearms, or ammunition, and that the two of you maintain separate residences. If you were living together and you need to go back one time to get any personal belongings, you can do so with the presence of law enforcement. Other than that, the two of you must maintain separate residences, okay?
You can tell him that.
Your Honor.
All right.
You should tell him that. So
I just
yes,
wanna double check.
the victim, my sister, she wanted to come to court, like she was trying to come, but the jail called her yesterday and told her that she wasn't allowed to come, that they weren't gonna let her in the courtroom if she came, but she was trying to come, and cause she stated herself to the police when they arrested me that she didn't want to press any charges, and then she wanted to come to court and state that as well, but she had got a phone call saying that she wasn't allowed to come.
I don't know who would have told her that, because we gotta.
It wasn't made, from what I see.
That's what I was, cause I talked to her.
I understand.
yes-
Well, hold on. Yeah. Be careful. All the phone calls are recorded here. So right now, because she's not here, I have to order that you have no contact. So I don't know what happened. I don't know why anyone would have told her that. We had a room full of people out there that, they usually call them and tell them to come to court. So I don't know what happened, but because she's not here, I have to order what we just did, okay? All right.
You're welcome.
All right, ma'am, your name?
Cinnamon Williams.
All right, Ms. Williams, this is 2023 MM2153 AO. Ma'am, your name?
Doris Jones.
All right. All right, Ms. Jones, you've been sitting out there all day or all morning, so you understand what's happening here today? All right.
Pretty much.
Go ahead and raise your right hand to be sworn. You swear a firm testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. You two living together?
She's my daughter. Yes.
So she stays with you?
Yes.
All right. You want her to be able to stay with you?
No.
All right. So do you want to have any contact with her?
It's not that I don't want her to.
I understand.
She's having some type of mental break.
Yeah.
That would cause her to put her hand on me, and that's unacceptable. She won't get help on her own, and I thought that they would take her to the Central Florida place.
Right.
And before this even got to this point, she lost her dad on New Year's Eve. I asked her when I saw her starting to go through what she's going through, it's just at another level. You understand?
I do.
I don't want anything to happen to her. I don't want anything to happen to anyone else. But she did something she has never done in her 28 years on this earth, and that's put her hands on me.
So that's the first time it's ever happened?
That's the first time me and her has ever been physical.
Yeah.
To have like a full-out altercation.
Right.
She punched me.
Yeah.
And then she tore up my apartment.
I understand. So are you afraid of her?
I'm afraid of what's going to happen.
Yeah.
Because I have other children. They're all adults. But I have other children. She can't go stay with my other kids because they have children. I don't want that in their home. If she get help, we'll be okay.
Right.
She has a license to carry. As soon as she gets money, she'll go get another gun. I took the one she had before.
We can order that she possess no weapons, firearms, or ammunition. I mean, but understand, it's just an order.
Right.
So it's incumbent on those
I don't want,
who know
I never
her
wanna
and
tell
who
my
are
kid
around
they
her
can't come
that
home.
if there's violations of any of these conditions that we impose, that you let someone know, okay?
The thing is, she doesn't feel like she has a problem.
I understand that too.
You know, and I feel like if she comes back and she's going to be disrespectful, calling me out of my name, I can't deal with that. And then,
All right, hold on one second. Ms. Williams, the reason I'm asking your mom all these questions too is we are gonna determine appropriate conditions of release, but also anything you say can and will be used against you. You're the defendant in this case, so everything's being recorded. So I'm gonna ask your mom some questions. It's not that I don't wanna hear from you. I'm appointing the Office of the Public Defender to represent you. I just don't want you to say things that that you may think are helping you out and in your best interest that may come back to bite you somewhere down the road. So you have attorney standing right there next to you. Anything you want to let the court know, it's best to run it through her because anything she says can't be used against you, okay? You understand that? All right, so Ms. Jones, I guess, so she isn't staying with you. Does she have somewhere else she can go?
no,
But you don't want her back in your house. It's fine. I'm not passing judgment on any of this. Things can get messy often. So so you don't want her staying with you? Is that what you said?
I want her to get some help.
All right, and what we're doing today is just conditions of release. I can't,
I understand. I'm just trying to give you the,
no, I get it. All right.
Your Honor, I'm not sure what Ms. Jones ultimately wants, but it does sound as though she does not want to live together. So you could do a no hostile contact, but maintain separate residence.
Yeah, that's what
She doesn't have anywhere to live.
Understood, ma'am. But it does sound as though you don't want her to live with you.
Right.
It's not that I don't want her there. She's having some type of mental break.
Understood, ma'am. But until she does get that help, do you want her in your residence? Until she gets that help.
This can be modified, so whatever we do
all I'm
today,
saying
whatever
is-
we do today,
Can I tell you this?
yeah,
Whether she lives in my house or the next house or whatever, something's going to happen. If she felt so comfortable to put her hands on the person that raised her, that gave birth to her, she is having some type of psychotic break. You can believe me if you want to or not. She's saying she can go somewhere else. If she goes somewhere else and causes harm to someone or someone causes harm to her, I don't want to have no regret that my daughter is going through something where she's not thinking clearly.
How about this? I can order that she have no hostile contact with you. No hostile contact means raising her voice, anything that can be construed as arguing, anything like that. And then, if she can come back and live with you, if you want, I'm just spitballing here, but then if all you do is pick up the phone and call and say, she's, if she's arguing with me, she's raising her voice, she's tearing up my house, whatever it is, and she'll be in violation of the conditions of her release, and then should be picked up and held until she can see the judge again.
Okay, can I tell you one more thing? And I don't want to, hold up your court. Last year, my daughter, this happened. She started acting weird around COVID. Last year, I had to do an ex parte to have her Baker acted. They came and got her, and they took her to this facility that's off of Mercy, but then they transferred her to Sanford. She was on medication there. They forced the injection on her. It was horrible when I went to pick her up, and I told her I would never send her back to that place again. It was bad. She was doing so well until her dad died this past December. And I asked her if she would just get help. She said yes. So it's like she was doing so good, but she is a threat to her own self. We were in the grocery store, just to give you one more example, and she likes to mumble to herself, and then she'll have these conversations. Well, someone walked past her, they thought she was talking to them, so they stopped. And I had to say something like, Cinnamon, who are you talking to? She was like, I'm talking to myself. Because if this woman was to hit my daughter, it's a whole situation in the store.
All right, I understand. All right, so here's what we're gonna do. All right, well, I've reviewed the arrest affidavit. I do determine there's probable cause. She doesn't qualify for
I
PTR?
think they were just concerns that we're not sure that she's gonna be.
We have like mental health PTR?
Like, you could order her to be evaluated for mental health PTR and then set bond or mental health in case she doesn't qualify. And mental health does that evaluation.
If pretrial was already concerned, as of right now, about my client's living conditions, it's very rare that they qualify anyone for mental health pretrial release. They hold them here, try to evaluate them. They wouldn't even qualify her for regular pretrial release.
Your Honor, I'm sorry to interrupt. Last year, they had to issue a purple alert for my daughter. The cops that even showed up yesterday, they weren't even aware what a purple alert were.
Okay.
And to be sitting up all night wondering where she is, what's going on with her, I don't know what all you can do. I don't want her here.
All right. I think we got a picture of what's going on. So what we're gonna do. So the living situation, that's what's keeping her out of mental health pretrial release?
Pretrial stated that she has no other friends or family, which is what their concerns were. Without the assistance of her mother, that's what the note says about.
I think mother's willing to, and correct me if I'm wrong, Mom, is willing to help if she's willing to.
1,000%.
We're willing to kind of address the underlying mental health issue, and we've got resources here to do that through pretrial release if she qualifies, right?
I mean, straight pretrial, we don't do anything with the mental health. I mean, we're not trained or qualified to do anything with mental health.
But if she qualifies for mental health pretrial release.
If she were to qualify for that program, then yes, I mean, they're specialized to mental health. But like I said, she'd have to be evaluated by mental health, and they'd have to approve her for that program.
They just,
I don't know if they would. We don't
they're,
work with
they're
them.
held here for days, Your Honor, and as long as I've been doing it, they don't qualify many people for mental health pretrial release, period.
Can we order, I mean, based on the testimony here today, can we order a Baker Act? No?
She don't qualify. Mental health pretrial, this is what it is, they hold, they do at least 5 days before mental health actually talk to her, see what's going on. See if she qualifies. Same.
All right, so here's the
It could
court's.
take up to 5 business days for them to like actually evaluate.
Well, that's what we're gonna do, because here's the court's concern. The allegations of firearms, the allegations
I
of.
took her gun.
I understand, but you also said that she'd go get another one.
She has a license. She can
I
go buy
understand, and
another
that's
one.
concerning, considering what you're telling me.
She's paranoid.
Exactly,
She
that's
made
what
me I threw out all my groceries because she thought I put something in her food.
I understand, there's obviously something going on mentally.
Oh, Mama, I'm gonna say this and I promise you I won't say another thing.
All right, you've promised before, but, all right, last.
I'm sorry.
Sorry.
She was assaulted when she was in the 10th grade.
Mm.
That had nothing to, that wasn't her fault.
All right,
But those memories and then memories that's being exacerbated in her mind is coming up. So it's like that compelled with all those things from when she was in the 10th grade, it's like it's making her be this person I don't know.
I understand, all right, so, all right, here's what we're gonna do. We're gonna do, what was it, it's a bond with mental health?
But it's bond or mental health PTR. That way, if she doesn't qualify for mental health PTR, she still does have a bond that she can get out.
Okay, so here's what we're gonna do. We're gonna do bond or mental health PTR if she, we'll do mental health PTR or a bond if she doesn't qualify.
What's the bond amount, Your Honor?
We're gonna do the bond, we're gonna set bond at $250 with the following conditions. That you possess, and this is the most important one for the court, that you possess no firearms, weapons, or ammunition. That you have no hostile contact with your mother or any other family members. And this is, I need a short answer, Mom. I can order that she maintains separate residences for you, or cannot. If you want, if you're fine with her coming back home with the no hostile contact, we can do that. Or I can order her to maintain a separate residence, she can figure it out. So what would you like to do?
She ain't got nowhere else to go.
What's that?
She don't have nowhere else to go. I can't.
I understand
have my
that.
kid on the street.
That's why I'm
I love
asking you.
her.
Would you rather her to have to figure it out, or would you, it's up to you. There's no easy answer, but we need an answer. All right, I'm just gonna order that you maintain separate residences, okay? If you wanna get that modified, I can tell you're not comfortable with her coming back home, that you're afraid of her when she.
Are you saying with the mental health assessment? Is
she's
that
not
what
gonna
you're?
qualify if she doesn't have anywhere to go.
Well, I don't know how mental health works. You were just saying.
If they do the assessment with her, she can come back home with all the other things that you said.
All right,
I don't have a problem.
So if she qualifies for mental health pretrial release, it's just gonna be no hostile contact. If she does not qualify for mental health pretrial release and she bonds out, it's gonna be maintained separate residence.
She still wouldn't have nowhere to go.
I understand, I can't,
Okay.
right,
I don't
it's
want
not a
that
perfect
for her.
solution.
No.
What's that?
She can just put the things in place that if something happened, that she'll come back. Maybe she'll go get some help. Can you do that? Cause I can't have my daughter homeless. This isn't even her. I don't know what else to do.
No, me neither. We're just gonna do no hostile contact. If for whatever reason she comes home, she starts acting like this again, you just call the police and she'll be in violation of the conditions of her release, okay?
Okay.
Because it sounds like you want your daughter home, you just don't want this person who's, right, I understand. So that's what we're gonna do, okay?
Okay.
You want her to surrender any weapons or?
Yeah, so any weapons that you do currently have, you need to surrender those to law enforcement within 48 hours of your release, okay? All right.
She took the gun.
All right, ma'am, you can,
I don't understand. It's okay. I won't speak.
ma'am, if you have the gun, I'm gonna ask that you surrender it to law enforcement within 48
I
hours.
don't have the gun. I took it last year.
Where is it?
I gave it to someone to hold that don't live near me. I didn't.
All right, we'll just leave it on there. Any weapons that she does have, she needs to surrender those within 48 hours. If she doesn't have any, she doesn't have any.
Okay.
All right. Good luck.
Okay, so do she have a bond or no?
She's gonna be screened for mental health, pretrial release. That could take 5 days or so.
Happy days.
And then if she qualifies, she'll be released on mental health pretrial release. If she doesn't qualify, she has a bond of $250, but they're gonna hold her in here while they screen her for the mental health stuff. All right?
Okay,
All right, good luck.
thank you.
All right, good luck, ma'am.
So how long?
I don't know. They screen for mental health.
Don't we, I mean, what's the red flag law? How do we do that? Like, if she wanted to go buy, how could we put on her record that if she went to go buy a gun somewhere, that she shouldn't be able to have one?
My mom told me to purchase a gun. She told me to go get my license.
It's fine.
Do we notify the sheriff? I think they know how to do that. Okay? All right. And council, just so you were aware, yeah, that's it, yeah. We were just talking about, red flag law and things like that, so.
We don't know. I told you I don't know how long it takes for them.
They're telling me it could take up to 5 days, so.
Okay, well, I'll be able to move out within 5 days.
I don't know.
No, I'm telling you, I will be able to move out.
Okay,
Okay.
all right. All right, it's lunchtime? Oh. All right, sir, your name?
Huh?
Your name?
Gabriel Boza.
All right, Mr. Boza, this is a Seminole County case, 211320 CFA. It's a warrant for your arrest. The bond and the warrant set at none. We're gonna stay the bond at none. I'll appoint the Office of the Public Defender to represent you while you're in Orange County, okay?
Do you know how long I'm gonna be here?
It's usually 24 hours. They come get you.
All right.
All right, good luck.
Thank you.
Kenningham? All right, sir, your name?
Russell Weldon Kittingham.
All right, Mr. Kenningham. You're here on a 2019 CF 55812 out of Brevard County. It's a warrant for your VOP warrant. Bond on that is set at none. We're going to stay the bond at none until further order from that court. I'll appoint the Office of the Public Defender to represent you while you're here, okay?
Yes, sir.
All right, good luck.
Thank you.
All right, sir, your name?
Clark Milliken.
All right, Mr. Milliken, you're here on a warrant out of Hillsborough County for child support. There's a cash purge on that warrant for $1,500. So you're just going to be held pursuant to that warrant, okay?
Okay.
All right, I'll appoint the Office of the Public Defender to represent you while you're here, just so you don't get stuck, all right?
All right, sir.
Good luck.
Your Honor, Mr. Maraca says he is Spanish.
What's your name, sir?
Manuel Moronta Moreno.
You don't speak English?
No.
How old are you?
20, oh. Oh, sorry.
Say how far. Huh?
26.
Yeah, where do you live? Where do you live? Okay, all right, just see how far we could go.
Good morning, Your Honor. This is Peresno Leon, certified Spanish interpreter. I have been previously sworn.
All right, good. Well, we have one individual who's just now informed us he does need the Spanish interpreter, okay?
Sí.
The interpreter can confirm there is connection with the headsets, Your Honor.
All right, this is an out-of-county case. It's from Leon County. Case number is 2020 MM 1269A. There's a warrant for his arrest. The bond is set at none. We're gonna stay the bond at none. And I'll appoint the Office of the Public Defender to represent him while he's in Orange County. All right, good luck,
¿Y
sir.
cuándo me pueden dar el fianza?
When can I have a bond?
You don't have a bond, so Leon County's gonna come get you.
Okay.
All right, good luck.
Okay. Your Honor, respectfully, what is the last name for the case?
Oh, I'm sorry. It's Moronta, Moronta.
Thank you very much, Your Honor. Does Your Honor still require the services of the interpreter?
As far as I know, no.
At your service, Your Honor. Have a wonderful morning.
All right, thank you so much. All right. All right, sir, your name? Your name, sir?
Rodriguez.
All right, Mr. Rodriguez, you're here for a warrant out of Manatee County. It's 2 counts. There's a bond on each count, $3,000, for a total of $6,000. We're gonna stay the bonds as they are.
It looks like his bond is pending, Your Honor.
Bonds pending?
Yeah, his
All right,
bond is
so
pending.
someone's paid the bond, you're gonna be, if nothing else holding you, you should be released as,
Excuse me.
Yeah.
I can release from here or no?
yeah, but you still got charges pending in Seminole, so you need to, or in Manatee. So you're gonna go take care of those, okay?
So I go back to the other county?
Yeah, you gotta go back to the other county. They just arrested you pursuant to the warrant that was issued in Manatee County. All right, good luck. All right, sir, your name? All right, Mr. Tubins, you're here on a warrant out of Lee County, case number is 21 CF 341. The bond in that warrant is set at none, so we're gonna stay the bond at none. I'm gonna appoint the Office of the Public Defender to represent you while you're here in Orange County until Lee County comes and gets you, okay? All right. It's usually, I don't know, Lee County, 24 hours, I don't know. It's gonna be up to them. All right. All right.
Sorry.
All right, sir, your name?
Willie Arnold.
All right, Mr. Arnold, you're here on a violation of probation warrant. The judge who signed the warrant set the bond at none. We're gonna stay the bond at none, and I'm gonna appoint the Office of the Public Defender to represent you in case 2012 CF 4036AO, all right? All right, sir, your name?
Jordan Honor.
All right, Mr. Honor, you're here. It looks like 2 cases. First case, 2019 CF 14207AO. It's a violation of probation. VOP warrant, set bond at none. We're gonna stay the bond at none. I'll appoint the Office of the Public Defender to represent you in that case. It's also case 2023 CF 4003AO is possession of cocaine. I reviewed the arrest affidavit. Do determine there is probable cause. I'll stay the bond in that case at $1,000. I'll appoint the Office of the Public Defender to represent you in that case as well, okay? All right, good luck, sir.
When's my next court date? My fault.
On the VOP?
Yes, sir.
I don't know. You'll get one soon, though.
I have one question, that's
All right.
it. On the docket-
We're now at 2, but go ahead.
I'm sorry.
I'm sorry.
On the docket, like, it has I put in a motion for early termination.
Mhm.
It's been on there since February 28th, something before, and I've been waiting for a court date. And now I get violated waiting on this court date, and I was supposed to get off probation.
Yeah, just because you asked for early termination doesn't mean it's early terminated, so that's.
I apologize, Your Honor. Did you? On the possession of cocaine, did you just stay the
Stayed the
bond?
bond, yeah.
Thank you.
And with all due respect, that wasn't really a question. That was just like a statement, but, all right. Good luck. Yeah. All right, Kimball, well, didn't we see him yesterday?
Yes, Your Honor, this is the one that I argued for an ROR on. They did an on-view. Normally, the state doesn't move forward on drug paraphernalia charges. That's all he was charged with. I would ask in this particular case that you set a bond on the probation, given that it was only paraphernalia.
Yeah, I thought about it. I'm gonna set bond at none until, because I don't know the facts of the case he was on probation on. I mean, it was a drug case, that's all I know. So I think if he's gonna get a bond, it's more appropriately addressed to the court where he was on probation. So, but I understand. I went back and forth on that one too. Yeah, we'll appoint the PD on the VOP too. All right, sir, your name?
Pedro Rivera.
All right, Mr. Rivera, you're here on a violation of probation, violation of community control, and violation of probation warrant. The judge assigned the warrant, set bond at none. We're gonna stay the bond at none. I'm gonna appoint the office of the public defender to represent you, okay? All right, good luck. All right, we'll appoint the office of the public defender to represent Mr. Rosa in 2022 CF 2693 AO. VOP warrant, set bond at none. We'll stay the bond at none. All right, sir, your name?
Santiago.
All right, Mr. Santiago, you're here in 2016 CF 7049 AO. The VOP affidavit alleges a violation of condition 17. Based on the alleged violation, we're gonna set bond at none until further order of the court. I'll appoint the office of the public defender to represent you, okay? All right, good luck.
Yes, I don't have.
And he has reporting requirements, just so he's reminded.
All right, you have reporting requirements to the extent that you are able to bond out. You need to comply with all reporting requirements within 48
Your
hours
Honor,
of your release.
I'm sorry, condition 16
17.
or 17, does it state what it was?
It was, yeah,
I don't have it with me. He wants to know
Okay.
exactly what.
It says, failing to actively participate in and can successfully complete a sex offender treatment program with qualified practitioners specifically trained to treat sex offenders at the offender's own expense and grounds. So if he didn't do the sex offender treatment program as required, that's the allegation.
Thank
All
you.
right. Yep. All right, sir, your name?
Ainsworth Spence.
All right, Mr. Spence, this is 2021 CF 1542 AO. So a violation of probation warrant. Judge assigned the warrant, set bond at none, so we're gonna stay the bond at none. I'll appoint the office of the public defender to represent you, okay? All right, good luck. All right, sir, your name?
Patrick Thomas.
All right, Mr. Thomas, you're here on a violation of probation warrant. The judge who signed the warrant set bond at none. We're gonna stay the bond at none. I'll appoint the office of the public defender to represent you in case 2017 CF 13287 AO. All right, good luck, sir. All right, sir, your name?
Anthony Gamble.
All right, Mr. Gamble, you're here in 2021 MM 3537 AO. It's a violation of probation. Bond is set at none. We're gonna stay the bond at none. I'll appoint the office of the public defender to represent you, okay? All right. All right, 2022 MM 8139 AO. We'll appoint the office of the public defender to represent Mr. Kuntz. We'll stay the bond at none pursuant to the warrant. All right.
It's a misdemeanor. Do you want to answer it?
Defense will enter denial, Your Honor.
All right. All right, we'll be in recess till
We can get a court.
12:30?
Your Honor?
We need a court date.
Two things.
Okay, I'm coming, I'm
What's that?
sorry, I heard you. I'm getting it right now.
Oh, she needs a court date.
And there's also the 33-day motions, Your Honor.
Yes.
Yeah. Oh, yeah, sorry, I was about to turn this off. I have them right here.
Case be heard Division 84, pretrial status is April the 11th at 8:30, courtroom 4B.
We also need the one in 80, the one that was before that.
Or he was,
He was a misdemeanor too. What was
Now
his?
we'll enter denial.
entered on, Gamble?
Yeah.
Okay, that case to be heard Division 80. VOP status is May the 9th at 9:30 in person, courtroom 9C.
I'm sorry, courtroom.
9C.
Thank you.
Okay, so what's it now?
All right. 23 CF 746 AO Goyens.
Granted, notice of non-filing.
2023 CF 2595 AO Lomas.
Denied and information was filed.
2023 CF 2589 Moore.
Granted, notice of non-filing.
Negron 2023 CF 2593.
Denied, information was filed.
Let's see. Oh, that was Hawks yesterday. All right, Hawk 23 CF 2474 AO.
Denied, information was filed.
Divinard 2023 CF 1567 AO.
Denied, information was filed.
All right, that 30th. All right, that's all those. All right, so now we're in recess. 12:30, does that work for everyone? All right. All right, we'll see you guys then. Self,
We have to do self, right? Self is gonna be this afternoon.
yeah, what'd I do with him?
I got him right here.
You got him? Okay.